what provision? Under what provision is this inquiry for? You want to recover from him some money.
My lord.
Isn't it required for a departmental proceed?
Yes, Lord. That will.
Then how do you do it?
Lordship may grant me some time. I will get instruction
For what?
why they have issued that recovery notice.
It is based upon the inquiry report.
Inquiry report.
Then you want to do it as per the departmental inquiry. Wouldn't he come under the Assam discipline and
Yes,
appeal
my
room?
lord.
So if you want to do it, do it.
My lord.
Now, has he retired?
Lordship, he is suspended since 2012.
You are still under suspension.
Yes, Lordship.
Suspension is done by the Dhubri Wholesale Consumer Society. We are not the.
So this recovery is given by the district deputy
Yes.
in register of
Yes.
cooperative society.
Yes.
But this can't be done without the proceedings under the discipline and appeal rule. So we set aside this and ask, give you the liberty to initiate proceedings. If deemed
My
fit.
lord.
You want only this.
Lordship, reinstatement. The question of reinstatement.
Reinstatement is where? You have it.
Lordship, in the prayer, we have
Reinstatement against what?
Lordship, suspension may be.
You have challenged the suspension.
Yes, Lord.
Page 27. Then Lordship, I am not appearing for the Dhubri Wholesale. I'm not aware whether he's reinstated.
Lordship, Annexure D, page 23.
Now you say that you have been illegally terminated. You have been terminated.
Lordship, suspended.
No, your prayer is illegal termination.
Yes, illegal termination, page 14.
Then not terminate. Then why have you done all these things?
Lordship, but suspension
This
is
court may
from
not
2012.
take up a serious note on this, but otherwise, isn't that an admission on your part, on affidavit? Then what do you want to do? You want the suspension, you want to challenge the suspension. Very well. The
Lordship,
suspension has to be challenged. Who has done it?
Page 27.
Office of the Dhubri Wholesale
Wholesale
Cooperative Conservator. Who are you? Who is that?
Lordship,
Is it a state?
respondent number. Lordship, it is the cooperative consumer.
No, is it a state?
Cooperative societies are under.
No,
It is
it may be, can't be a state. I don't think it is. It's a society registered under the Assam Cooperative Societies Act. But would it be a state?
Lordship, have gone through some judgments, it is contradicting.
Hmm?
Some
No, obviously, if they are discharging public duty, in that respect, this court can very well interfere. But suspending you, would that be amounting to a public duty? Hmm?
I'm not aware.
You are not aware means you are the petitioner.
Yes, Lordship, but
Then,
this
yes, madam, you want to help her?
Lordship, my contention is that the deputy registrar has issued a notice for recovery of the amount, but we are not the authority who has suspended the petitioner. It is the chairman of the whole
Understood, understood. I have understood that. But how can this court
Yes, madam.
interfere into an action by these people? The
Lordship,
cooperative.
Chairman.
Lordship may quash that order. Will pass order.
So you
Yes,
don't want to
suspend.
press this as regards the challenge today.
Only recovery amount, Lordship.
Heard, Miss?
G. Swami.
Please, Swami, the learned counsel appearing on behalf of the petitioner. And Ms. M.D. Bora appearing on behalf of the respondent number 1 and 2. The learned counsel for the petition at the outset has submitted that she is not pressing on the challenge to the order dated 30/4/2012, on the basis of which the petitioner was put to suspension, was put into suspension by the respondent number 3. She further submits that the respondent number 3 may be struck off from the array of parties. in that view of the matter, the respondent number 3 is struck off from the parties. The registry shall make necessary correction to the cause title of the writ petition. The case of the petitioner herein is that the petitioner is a government servant. You're a government servant?
Yes.
And by the communication dated and the government servant and the Assam Discipline and Appeal Rules, Assam Services bracket Discipline and Appeal Rules 1964, for short the rules of 1964 duly applies to the petitioner. The Learned Counsel submits. The Learned Counsel, drawing the attention of this court to the communication dated 6/2/2019, submits that the respondent authorities have directed recovery of the amounts mentioned in the said order dated 6/2/2019 without there being a departmental proceedings initiated against him. Upon hearing the Learned Counsel for the petitioner as well as Ms. M. Deborah, the Learned Counsel appearing on behalf of the respondent number state, it appears that the order dated 6/2/2019 by which there was a direction to make certain recoveries from the petitioner was made, wherein there were certain directions to make certain recoveries from the petition. It was based upon an inquiry report submitted by the junior inspector oblique auditor of the Cooperative Society, Dhubri, some discipline and people. Rule 7(3), Roman of the rules of 1973 envisaged the penalty of recovery from pay of the whole or part of any pecuniary loss caused by the negligence or breach of order to the government or the central government or any other of government, state government, or any local or other authority to whom the service of the government servant had been lent. In terms with Rule 911, the penalty specified in clauses Roman 1 to Roman 3 of Rule 7 is a minor penalty. It further transpires from Rule 9.1 of the Rules of 1964 that no order imposing on a government servant, that there can be no order imposing on the government servant any penalty specified in Rule 7, except after an inquiry held in the manner stipulated in Rule 9. Admittedly, in the instant case, there has been no departmental proceedings. And admitted, from a perusal of the order dated 6/2/2019, it transpired that it is on the basis of an inquiry report submitted by one Goreram Roy, Junior Inspector Auditor of the CS Dhubri, that the imposition of the penalty under Rule 7.3 have been imposed upon the petition, which is contrary to the provisions of the rules of 1964. Under such circumstances, this court, for the interest of justice, sets aside the order dated, the communication dated 6/2/2019, issued by the District Deputy Register of Cooperative Societies, Dhubri. It is, however, made clear that the setting aside of the order dated, the communication dated 6/2/2019 shall not preclude the authorities, that is the respondent numbers 1 and 2, to appropriate proceedings under the rules of 1964 and take such action as deemed fit in accordance with law.
My lord, Lordship may kindly have a look, page 28 for a moment, the inquiry report. I have stated in the last paragraph, does the allegation of unjust liabilities fixed shown against him as per his petition is not established, after the eviction.
Item number 2.
May it please your lordship.
Yes, Mr. Chaudhary.
My lord, without even troubling on lordships, for lordship's recent judgment, this matter can be dealt with.
Yes,
If your lordship will kindly take note of 2-3 dates matter.
yes.
My lord, 10/11/22, the petitioner was arrested.
Hmm.
My lord, because he was in custody for more than 48 hours. Therefore, on 12/11/22, my lord, he was deemed suspended.
Hmm.
Then, my lord, 14/11/22, he was granted bail by the court, my lord. Then, my lord, 12/12/22, bail order was communicated. And on 12/3/23, my lord, because February was 28 days, 90 days period is over, till that no charge sheet has been filed. So by virtue of the first limb of Ajay Chaudhary's formulation, that there is a requirement of filing charge memo or charge sheet within 90 days. So my lord, I'll be covered by that. So
When
the
did
bail
you
order
inform-
was communicated
Yes,
on 12/12/22. My lord, in
12,
fact,
12.
yes,
Oh, we have crossed the 3 months.
yes.
As
In
of
fact,
now.
my lord, this order, we were not aware of the lordship judgment.
Uh-huh.
So my lord, we haven't annexed that, but we are having that order.
Because Mr. Chaudhary, this court felt
Ah.
that in Rekibuddin, the team suspension aspect was duly brought in without discussing, because one thing is very clear, that if he remains in custody Under no circumstances that can.
No question of giving that benefit.
Just for example, a person is arrested in an NDPS case
Yes.
or in a PMLA case. The period can't be 90 days. It may go extend to 180 days.
Yeah.
Then can he be, by virtue of Ajay Chaudhary, reinstated for not being given?
Well,
It will have-
there is an argument.
Yes.
I'm reserving that argument for an appropriate time.
Yeah.
Just
Yes. Yes.
it's not. I mean, people also to kindly have the rules, my lord.
Yeah.
1964 rules.
Mm.
If your lordship should kindly come to rule 6.2.
Mm.
My lord, what your lordship has held is possibly one of the way of looking at it.
Mm.
I was just thinking whether this could also be one of the way of looking at it.
Yeah.
Please, I'll read. I'm reading sub rule 2, my lord.
Yeah.
A government servant who is detained in custody, whether on a criminal charge or otherwise, for a period exceeding 48 hours, shall be deemed to have been suspended with effect from the date of such detention by an order of the appointing authority, and shall remain under custody, remain under suspension until further orders.
Hmm.
My lord, the mandate of rule 6.2 is the moment the detention is more than 48 hours, then he shall be deemed to be under suspension until further orders. Now, my lord, in my humble understanding, this until further order phrase has been qualified by the proviso.
Hmm.
Now, let us read the proviso.
Hmm.
Provided that where the detention is made on account of any charge not connected with his position as a government servant, or continuance in office is not likely to embarrass the government. I'll read the or as and, my lord.
Yes.
And the government servant in discharge of his duties, or the charge does not involve moral turpitude, the appointing authority may vacate the suspension order made or deemed to have been made. This is of great relevance, my lord.
Yeah.
In my humble understanding, subject to what your lordships may say, 6.2 does not make any distinction between a 6.1, suspension or a 6.2 suspension when it comes to the power of appointing authority to do vacating. Yes. Or deemed to have been made when he is released on bail or is not otherwise in custody or imprisoned. So, my lord, in my humble understanding, my lord, the rule-making authority thought it fit and proper that as long as he is in custody, there cannot be any question of,
Reinstate.
revoking the order.
Yeah.
Now, my lord, the rule-making authority, of course, took note of the fact that when he is released on bail or is not otherwise in custody. Now, your lordship is right. When your lordship takes note of, gave the example of in a case where the detention is permitted under the law for more than 90 days, there what will happen? That is an aspect, of course, my lord, I did not consider.
Therefore, if you see my
Yes.
judgment in Rafid Ali, if you have a look copy, I said
having a copy, my
that these are the three circumstances on which a person can be otherwise once he is outside, these things can be taken into account.
Right.
Now there is the fourth circumstances has therefore come in view of Ajay Chaudhary reading it with that if you don't give it, therefore in the penultimate paragraph I have stated that if
Yes,
the
a
person,
fourth
concerned, if the authority concerned exercises the power in terms of the conditions 1, 2, and 3, which is there here, then it is okay. It can be done prior to that also. But if he wants to otherwise invoke only Ajay Chaudhary, then 3 months has to be given from that period, from the date of intimation. Because without intimating, the appointing authority may not know.
I think, my lord, there is a possible way of looking at it.
Because these are the three circumstances.
Yes.
Just for
Look at the
example, a
rule.
person is released, he may on the very day, he may give it out there. And on that day, taking these three conditions,
He can be released.
he can be reinstated. But if you are insisting only on Ajay Chaudhary, then you have to give this 3 months from the date of his intimation.
Correct.
Now, what happens out here, as I have been taking up these suspension matters, Ajay Chaudhary, top portion is okay, which is in their benefit of this person concerned. But the second portion of paragraph number 21 hits these people.
That review part.
No. Says, yes, that they can't be put in the same place or they may have liberty so and so. So therefore, they don't inform that.
But I think, my lord, is it possible to
Because
But
unless
in
he is
cases-
inside,
in cases where detention is less, I mean, permitted is less than 90 days in
60 days, just for example, a case of 60 days may be there. Then he may be released out there. But the Supreme Court in Ajay Chaudhary took it up that let us take into 167, the proviso to 167.2. And the maximum period was 90 days.
167 2 takes note of both, 60
but-
days or 90 days as the case.
But the
may be.
Supreme Court took the 90 days.
In fact, my lord, in the Assam rule also,
Yeah.
there's an executive order. It speaks of 90 days.
The manual also says
Manual,
about 90
manual of
days.
disciplinary procedure.
90 days, yes.
And my lord, in this case, perhaps, my lord, my case would be covered by the fact that charge sheet has not been issued.
On
Within
12,
90
12, 12 2, you,
12,
you
12
informed when?
We have communicated on 12. And 90 days was over on 12/3, my.
No, when was this received? This is not given by hand.
Posted, my lord.
Then you have to give minimum 7 days.
Even then, my lord, today I think 1 तारीख. Today is 17.
We'll do one thing.
My lord.
You should give a short notice for 3 days.
On
I don't
Monday.
disturb the respondents without the notice. You find it out. We have it on today, 17.
On Monday, Wednesday, my lord.
My lord, give me 1 week time because now budget session is going on, my lord. Officers are very hard to catch, my lord.
Okay, 24th. 1 week, as
1
you
week,
say.
Yes.
My lord.
24th. Heard Mr. K. N. Chaudhary, the learned senior counsel, assisted by Mr. J. Patwari. And you are, this is under the Assam rules, no?
6/2.
And Mr. Adhor appears for the
lord, I'm
respondent
appearing for-
number. Oh, Mr. Where is, you are, Mr. L. Dutta appears for respondent number
2 and 3.
2 and 3. And Mr. Adhor appears for respondent number 1. This information you have to get.
Yes, lord, I'll take it.
Issue notice making it returnable on 24/3/2023. Mr. Patwari, kindly bring this on affidavit.
My lord, yes, yes. In fact, my
As
lord,
the-
if you would have been aware of your lordship's order when you filed the petition, then you would have brought it on record.
Yes.
Because in those situations, it was not required. Now it has become necessary.
As the respondents are duly represented, extra copies of the petition be served upon them during the course of the day. The case of the petitioner in brief is that the petitioner
Arrested on 10/11.
was arrested pursuant to an FIR filed on 12/6/2022 before Dula Police Station in connection with the death of a girl child on 11/6/2022. The said case was registered and numbered as Dhula PS case number 114/2022 under section 376/302 IPC, read with section 10 of the POSCO Act and read with section 14 of the Child Labor (Prohibition and Regulation) close Act 1986. Thereupon, the petitioner was arrested on 10/11/2022. Subsequent thereto, by the bail application on the basis of a order dated 14/11/2022 in bail application being bail EA number 3045/2022. The petitioner was released from custody. In the meantime, while the petitioner was upon the petitioner being arrested on 10/11/2022, the respondent authority, the appointing authority, by an order dated 12/11/2022, placed the petitioner under suspension with effect from the date of his arrest. The learned senior counsel has submitted that on 12/12/2022, the fact that the petitioner was released on bail on 15/11/2022 was brought to the notice of the appointing authority. By way of by sending the said communication by registered, by speed post or registered AD.
Registered posted, I'm told. है ना?
By registered AD. The learned counsel for the in that regard, the communication dated 12/12/2022 was placed before this court. This court deems it proper that the said communication along with the postal receipts be brought on a court by way of an affidavit, additional affidavit. The case of the petitioner hearing is that applying the law as laid down by the Supreme Court in the case of Ajay Kumar Chaudhary versus Union in India, reported in 2015, 7 SCC 291, as well as the judgment of this court in the case of Rafed Ali versus
WPC number 455 of
dated
My lord, judgment is dated, my lord,
17/2.
17/2/23.
17/2/2023.
Yes.
Rafed Ali versus. As the petitioner had duly intimated the respondent authority, his appointing authority about that he had been released on bail, released from custody, and is otherwise not in custody. Released. Have been released on bail. And there has been no memorandum of charge oblique the charge sheet having been served upon the petitioner till date. The petition, the further continuation of the suspension is in the teeth of the law laid down by the Supreme Court in the case of Ajay Kumar Chaudhary Supra. On the returnable date, the learned counsel, Mr. S. Dutta, shall take instructions, shall apprise this court upon instructions as to when the communication dated 12/12/2022 was received, and as to whether the memorandum of charge oblique the charge sheet has been served upon the petitioner in the meantime. List according. You take this, huh?
And number 3,
Yes.
My lord, the petitioner was appointed as Assistant Sub Inspector of Police in the year 1989 at Nagaon. Thereafter, he was transferred to various places like Shivsagar, Manipur, etc. places. But due to some departmental proceeding, he was demoted to the post of Assistant Sub Inspector of Police after promoting Sub Inspector of Police. So in that manner, he suffered a some shock and also got some mental illness. So for a considerable time, he could not join at Bongaigaon, where he was asked to join. In the meantime, he has been retired from that post in 2009. Thereafter, he filed petition to get some pensionary benefits and other dues, etc. Pension and other pensionary benefits. But that was not considered. Then, my lord, my wife filed a petition before the authority that kindly provide the service book of my husband so that I may submit my grievances before our lordship, including claim of pension and other pensionary benefit. But the authority replied that as he has not joined at Bongaigaon as per order of the court, order of the authority, so we are not in a position to pay his last pay certificate. That was the case. Then challenging that order as well as the inaction of the respondents, he earlier filed a writ petition. That lordship may kindly see page 22.
They withdrawn it.
That was withdrawn without showing any reason, but no liberty was taken. But even then, my lord, we have decisions also that liberty is not a must. Now we have filed this.
No, liberty is not a must if there is an effect of the fundamental rights.
A fundamental right is there. So that judgment we have brought. Now, my prayer is this, my lord, the authority may be asked to show as to why my pension and other benefits have not been provided. Suppose I have not joined there, that is another aspect of I have said that due to my illness I cannot go. And also kindly promote me and keep me at Noga. But that was not considered. In the meanwhile, period of superannuation came. So now they should pay me the pensionary benefit and other benefits, but they have not yet paid. On the other hand, I am suffering from illness. My family is also suffering. So that is why limited prayer the authority will pay my pension and other service benefit.
No, what are you are asking for payment of pensionary and retirement benefits, not service benefits. There's a difference out there.
Retirement benefits.
Yeah. Heard Mr. M.U. Mohammed, the learned counsel, appearing on behalf of the petitioner. Mr. Pension, who is appearing?
I am Lord.
Okay, Mr.
I'm
H.
for
Sharma
1, 3, 4, and
appears for
6.
the respondent number 1, 3,
4 and 6.
4, and 6.
May I point out, Lord?
Yes.
He has two prayers.
Prayer for what?
Prayer for getting that benefit or to direct us to dispose of the representative. That is also there.
Why should I direct?
Lordship.
Why should I direct that?
No, Lordship, that prayer
First,
is
this
also
court
there.
has to be satisfied. He has a legitimate expectation.
Lordship, it is there, Lordship, but as because his prayer is there, I have to pass.
No.
I am pointing it out.
And
to
Mr.
Lord.
Mahmood knows he wants a full-fledged order to get it. Yes. One, so and Mr. R. Purpujari appears for the respondent number 2. And Mr. A. Hassan appears for the respondent number 5. Issue notice making it returnable on 26th of April 2023. The case of the petitioner herein is that the petitioner claims to be entitled to his pension and retirement benefits which have been not given to him for the last 26 years.
2009, no. 2009, I have
Due to him for his 26
11
claims
plus 3,
his pensionary and
Nearly 14
retirement
years.
benefits.
nearly 14 years.
to which the petitioner is otherwise entitled to. The respondent's authorities shall on the returnable date apprise this court as to why the petitioner have not been granted the pension as well as the retirement benefits. तो ऊपर लिखिए ना copies of the extras within 3 days, huh?
Not Muhammad Mahmood. My name is Emi Mahmood. Not
I know that.
No, here,
Mention as
Muhammad.
Mahmoud,
you are
Emi or Mahmoud.
Adna 4.
You take steps, huh? Within 3 days.
Yes.
Copies, sir.
Yes.
Yes. Where is the petitioner? What is the case? What is he asking for?
Basically,
Yeah,
he's asking for proportionate pension
Uh.
because he has given service of around 17 years, and he is claiming on the basis of a division bench judgment of
What is that?
2015. It starts at page number 54. It's the 2015-23 for 2015 judgment.
What is that? What is it? It's a division or single bench?
Division bench, actually, Your Lordship. Earlier, there is a division bench judgment, and this follows the single bench judgment followed the division bench judgment. He has not annexed the division bench judgment.
Okay. Now what is it?
At page number 60,
60.
page 60.
In view of the fact that the petitioners are covered under right. So he's asking for something similar.
But the thing, the impugn order is at page number 45.
If I return time back, but what do you say about 108?
Your Lordship, I have a preliminary objection with regards to the maintainability due to on the ground of delay in lashes, because he retired in the year 2010. 27.
Pension.
Your Lordship,
Pension one.
and
Pension is always recurring.
and
Area is okay, but pension is recurring.
pension, but this particular issue as such, it was decided way back in 2015 when other petitioners they approached Your Lordship, but he was a fence sitter, and all this while he was sitting. Now in the year 2023, he somehow wakes up from his slumber after a period of 13 years, and he approaches Your Lordship for payment of this proportionate pension. Otherwise, 108, it doesn't say that much, because if Your Lordship peruses
No,
through,
no, it doesn't say, but he is entitled to some pension.
he doesn't have the qualifying service of 20 years,
108 says 10 years.
minimum 10 years.
Then
Minimum 10 years.
you require that 20 years only in respect to a person who is not confirmed.
Not confirmed.
This person is a confirmed person.
Your Lordship may kindly grant me some time to get this OM. What does this OM say? Because he has
I'll
not-
issue notice on this.
yes, Your Lordship.
I'm only issuing notice.
Because this OM also needs to be gone through. I don't have that OM right now.
Mr. D. Bora, the Learned Council appears on behalf of The respondent number 1,
All the
2, 3, 4, and 5 and 6. Issue notice making it returnable on 3rd of May 2023. The petitioner is directed to take steps by serving extra copies of the writ petition within 7 days from today. The petitioner herein have challenged the order dated 7/9/2000, no, 1/10/2022, isn't it?
It's 3/9/2022.
3/9/2022, whereby the Deputy Inspector General of Police Administration have rejected the prayer of the petitioner for proportionate pension and other benefits. The learned counsel appearing on behalf of the respondent shall apprise the court on the returnable date as to why the petition shall apprise the court upon either on instruction or by way of an affidavit as to why the petitioner is not entitled to the proportionate pension. The maintainability, the question of maintainability of the writ petition, the maintainability of the writ petition shall also, the issue of maintainability of the writ petition is kept open. 5. Yes, Mr. Pulkastia.
My lord, this is the covered case regarding beard increment.
Huh?
This is covered case by your lordship. The order is there.
Covered case for
Covered
what?
case. The PF for beard in advance increment for beard, my lord. But in fact, my lord, what happened? This petitioner
What do you want?
advance increment, my lord.
Oh, that one.
Yes,
After completing this
beard degree.
on a particular date, no, 1/7,
Yes,
2022 or something like that.
yes, sir. The judgment is there.
Give it to me. You need to verify
Yes.
by the inspector of school. In a recent judgment, I passed on that. This is it.
Paragraph 7.
You are all assistant teachers?
Subject teachers come assistant.
Oh, Mr. B. Puka. And who appears for the respondent? Who are the respondents here? Secondary
Only
education.
secondary education, Lord.
You are appearing?
Yes, my lord. I am.
Ian Sharma?
And you, Sharma. my lord.
You Sharma. I always confuse. Okay. Very good. Appears for?
Respondent
1
number,
to 5, my lord.
secondary education department. Respondent number 1, 2, 3, and 4, my lord. 4, 5.
All the
All the respondent, my lord.
appears for all the. Case of the petitioner herein is that the petitioners are subject teachers and assistant.
Public assistant.
Subject assistant teachers having B.Ed degree and therefore entitled to one advance increment, which however have been denied to the petitioner. So the AI has submitted that the coordinate benches of this court have also passed orders directing necessary verification in that regard and for passing appropriate orders. If upon verification it is found that the petitioner having been, in that regard, reference have been made to the order dated 10/3/2000. WPC number 120. Taking into account the auto. As well as the direction issued by the Joint Director mandated, this court is also of the opinion that if the petitioner have acquired a B.Ed degree from UGC recognized university with NCT approved and joint institution before 3/7/2012, that the petitioners would be entitled to one in this respect, however, would require verification to be carried out in the level of inspector of schools, that is the respondent numbers
3, 4, 5.
3, 4, and 5. In the respondent person within submitted presentation along with the certified copy of the making the in a period of 3 months from the date of submission. With the above, what like
Extra copies.
why do you need an extra copy? Matter, it's finished.
Oh, yes. Okay.
6.
Yes, Mr. Goswami.
They were all employees of different agricultural corporate fields.
What do you want?
Now they have not received their salary.
They will not get all why the area salary till the date of retirement shall not be paid to them, and why they will not get all the retirement benefits as has been given to the government employees as per the orders of Iman. Who are you?
We are all agriculture corporations employees. And out of
Agriculture
different agriculture corporation methods.
corporation
Yes.
employees. Yes, then
They have been paid up to March 2016. Regular salary was paid. But till now, they have not paid their salary. Some of them has already been retired. Only except
agriculture. Okay.
corporation. It is under Millard Agriculture Department.
Okay.
Earlier, Millard, they came up.
Now, whether that corporation still remains?
No, Lord. No, Millard,
Ah.
what happened? I have submitted Millard RTI application, whether it has been closed or not. It is not closed.
It is defunct, Lordship.
Formally-
It is defunct, Lordship, as per my instructor.
Defunct is
corporation.
different from being closed, isn't it?
Yes.
It must be declared closed by the cabinet decision, Millard. They are all Millard corporations. But it is not till today, it is not closed. Some are still there, but their salary has not been paid. They have received up to March 2016. Some of them retired in 2017, some of them.
Madam, what have you done to those? Some employees you must have absorbed
We
somewhere.
have already paid 4 crores 47,029.
Ah.
So 4 crores 47 lakhs 29,000, Lordship.
Two?
To all those employees, those who have filed with petition before, Lordship. And
This
this
one?
set of, Lordship.
These petitions you have paid?
Regarding this.
Yes,
Yes, Lordship.
they have received up to March 2016.
Now, when did you pay that 4 crore 47 lakh?
It
In
is in
2018,
his
Millard.
amendment. Lordship, page number 16 in his writ petition, Lordship.
16.
Paragraph 9.
In 2018, they have received this money. After
So,
this,
Lordship, I
honorable
need to
court
take
has
my
passed this
instruction
order.
regarding this.
No, you will get. Don't worry. This was done in well. This order was of by the order they dispose of the contempt as well as the month. What is the order in the writ appeal? Let us see.
Yes, my lord. That is in page 17, my lord. Page 70. The direction was this, my lord.
Submit to the government is speech of the matter and the process for working out the revival of the corporation is on that and that a substantial amount of compensation has already been paid at the balance amount to be paid in full. Keeping the submission made at the bar and the facts and materials directed to the respondent shall prescribe the amount in 6 months and pay. Liberty to revive the contempt. Why you have not gone for contempt?
Contempt was filed, my lord.
Then
Then, my lord, they have filed this, submitted, paid this amount.
understood. No.
Now, after this order, my lord,
Ah,
they have not paid. Then we have filed another contempt petition.
ah.
Then they have filed and we have withdrawn this contempt case.
They have paid.
Yes, they have paid up to March 2016.
No,
But
but
they are-
you still have the liberty. Revive.
No, my lord, what happened? Because that contempt case was filed and it was disposed of.
That is different. But what about this? Respondents are, however, at liberty to revive the contempt petition if the order is not complied with within the time frame.
We have revived that contempt petition.
You filed a fresh contempt.
Yes,
That's a different thing. Have you revived it?
not revived it, but my lord, we have filed fresh contempt petition. That
So
was
this,
also closed.
this order still stands. Don't you
Yes.
think so? Why you are not reviving it? When a matter has gone to the division bench,
Division.
you want again to start from the single bench.
Lordship, what happens after closure of the my lord, contempt case? They have submitted different representations, my lord, and they say that will pay, but
Understood, but isn't it the same thing? When the division bench has categorically mentioned that they have been given a time frame of 6 months for the purpose of making the reviving and also making clearing all current and area salaries. Isn't it the case by them that you should be done something to that effect?
my lord, as because we have already
You
filed
want
one
to you want to start a fresh,
contempt.
thereby you are, wouldn't you be touching on that?
Whether it will lie or not, we don't, it will take quick. Because we have filed one.
Heard Mr. R. Goswami, the learned counsel, appearing on behalf of the petitioner.
Only two petitions are 3 and 7 are working. Others have retired out of 8.
On behalf of the petitioners. Ms. Arbora
Lordship, 1 and 3.
appears on behalf of the respondent number 1 and 3. Mr. Arbor Pujari appears for respondent number 2. Issue notice making it returnable on 3rd of May 2023. The case of the petitioners herein that accept the petitioner number
3 and 7.
3 and 7. The others have already
Retired.
retired.
Yes.
Have you retired or means have crossed the age of superannuation? There's a difference out there, no?
And yes, my lord, it is
Because you are not working, it's defunct. Have they given you a notice of superannuation?
my lord, NHR 1 page 28. It is retirement on superannuation. Page 28. I am to inform you
This was given in 2018.
Yes.
Have retired, except petitioner number 3 and 7. The present petition has been filed claiming payment of the area salary as well as retirement benefits to those petitioners who have retired. The respondent on the returnable date by way of an affidavit and or instructions shall apprise this court as to why the petitioners have not been paid their retirement, their area salary, as well as those petitioners who have retired in the meantime have not been paid their retirement dues.
Order amended two petitioners, those who are working, they have not received their salary.
That is why salary.
Obviously.
7,
Mayor, please, your lordship.
Hmm.
Hearing your lordship, the petitioner on attending superannuation retired on 31/10/2021. Your lordship. Then your lordship, the pension paper was forwarded.
What are you challenging?
Now the accountant general has returned my pension papers with observation to certain observation and directed the respondent number 3 to resubmit the same.
Who are
That-
you?
That is not been submitted.
You are the accountant general. Right. I was thinking that this is some case pertaining to,
No, only my limited prayer is to resubmit the pension paper after fulfilling those.
simple.
Yes, yes.
They have told the DG, the respond number 3, to submit something to do some. The DG has sent it to the respond number 4, the commandant, to do an inquiry because there are 3 wives.
Yeah,
He has 3 wives.
3 wives.
3 wives. So
Okay.
that's why I think my telephonic instruction just now is that the commandant has issued some notice to them to come and settle up the issue because he has 3 wives who wish to be nominated and all that.
8 years
wives?
already.
How do you nominate somebody else? Tell me.
A Muslim person that
No, can you nominate other people?
first wife, your lord.
Patents?
Yes.
It is a different thing. The other wives would have the right of maintenance as per the full bench.
Yes.
That is another aspect. But it is only the case that he is the retirement. So the question of having 3 wives of 4, not more than that. It is a different, that doesn't have anything. So we direct saying that the law laid down is to the effect is it is only the first wife who the eldest of the wife would be entitled to, and in her when there is a death on the family, then there will be the other persons will come.
Right now he's alive though. So confusion was because of the 3 wives.
If the eldest of the wife expired, then the surviving
Then yes.
persons get. So we just put the law out there and then finish.
Ask
That is
them to
also
do
the
the
observation.
Yes.
That is also the observation.
Huh?
There was also the observation of the accountant general.
Yeah.
First wife.
See?
First wife.
Page 13.
Page
Page your lordship.
13. 1, 3.
Original is a photocopy of original 15. 2, 3. A clause B. Self-attested copies of PAN card of government servant and his first wife may be submitted for incorporating the same in the pension payment order. DTO is specially requested to personally verify.
You are the husband.
Yeah.
You have not got, you have retired
No, retired.
and you have not got the pension because of this.
Yeah.
Because
One
you
of
have
the
married three times.
That is.
one of the issues was that he had married without the permission of the government, even though he's Muslim, so that's why it may have been a misconduct. That was one of the.
It was different thing. Yeah.
Don't bring those issues up.
It is different thing.
Yes, your name?
R. Majumdar, Your
R. Majumdar, the learned counsel appearing on behalf of the petitioner. Mr. C.S. Azorika appears for the respondent number 1, 3, and 4. Mr. R. Dhor appears for the respondent number 2. The case of the petitioner herein, that the petitioner was appointed as an officer, oblique, a member of the Home Guards under section 63A of the Assam Home Guards Act 1947 with effect from 23/6/1983. While serving, the petitioner was promoted to the post of constable under the establishment of the respondent number 4 by an order dated 15/3/1985, and he continued to serve in the state post till he retired on 31/10/2021. Thereupon, the papers of the petitioner were sent by the respondent authority, by the concerned respondent authority
19/2, 22.
the pension papers, huh?
Yes.
By the communication dated 19/2/2022 to the respondent number 2 for finalizing the pension and other retirement benefits. The respondent number 2, upon receipt of the pension paper, issued a communication dated 22/7/2022, thereby intimating the respondent number 3 that the pension case cannot be finalized and the pension papers were returned back to the respondent number 3 with a clear observation that there's, as per the service book entries and the relevant pension documents submitted, retired constable Nasiruddin Loskar performed second and third marriage during the subsistence of the first marriage in violation of Rule 26 of the Assam Civil Service Conduct Rules 1965. However, by letter dated 22/7/2022, the respondent number 2, now full stop. Have informed that the pension papers cannot be finalized and the pension papers were returned back to the return with certain observations. Full stop. By the said letter, the respondent number 2 also informed the respondent number 3 to resubmit the pension papers of the petitioner by enclosing self-attested copies of the PAN/Aadhaar card of the government servant and his first wife for incorporating the same in the pension payment order, PPO. Further to that, the drawing and disbursing officer was specifically requested to personally verify and attest the joint photographs with names on the reverse to avoid any complications. It was also mentioned that the provisional pension may be granted and paid till finalization subject to the recovery from final pensionary benefits. It is the case of the petitioner that there has been delay on the part of the respondent number 3 in submitting the pension paper, for which the instant writ petition has been filed. I've heard the learned counsels for the petitioner as well as the learned counsel appearing on behalf of the respondents. Mr. C.S. Hazarika, the learned counsel appearing on behalf of the respondent number 1, 3, and 4 had submitted that the petitioner has 3 wives. And it is on account of the same. There has been a problem in submitting the papers as per his instructions. It is well settled. It is well settled by the judgment of the full bench in the case of MUS Titi Junufa Bibi versus Padma Begum, reported in 2022 HCC Online DAU 2000, that in terms with Rule 143 and Note 1 of Rule 143(2), it is the eldest of the server. It is the eldest wife. He is the eldest of the eldest widow or the wife who would be entitled to the pension. And it is only upon the death of the eldest entitled to the family pension. And it is only upon the death of the eldest wife oblique the oblique widow. The surviving wives oblique widow would be entitled to surviving wife oblique widow would be entitled to the family pension. And thereafter the minor children. This aspect applies only in respect to those persons who are covered by the Mohammedan law. In view of the law as laid down by the full bench, this court finds no reason as to why the respondent number 3 should not send or should not resubmit the pension papers of the petition. In terms with the observations made in the communication dated 22/7/2022 by the respondent number 2. Therefore, this court disposes of the writ petition at this motion stage itself, thereby directing the respondent number 3 to forthwith on the basis of a certified copy of the order being served upon the respondent number 3 to resubmit the pension papers. In terms with the communication dated 22, Mr. Counsel, you are referring to 22/7.
Yes,
Where
yes.
is 22/7? It is
Lordship,
22/5.
23.5. Your Lordship.
The
23.
date is bottom. Your Lordship may kindly see at the bottom memo 22/7/22 bottom. Port.
That's a seal for, maybe it was on the data receipt on by someone. Your Lordship.
Ah,
No, it is not.
it is 23/5 code you, huh? 23/5.
No.
Thereby sending the name of the first wife of the petitioner for being recorded in the service sheet, as well as all pension documents. With the above observations, the instant petition stands disposed.
After Your Lordship, the verification by DDO, that clause will not be required. Your Lordship has not, in the last observation direction, that all these factors like the joint photographs and all these factors.
Oh,
will
these will be
Did you-
required. I've said in terms with you by sending the name. That is why I've said in terms with this communication dated 22, by sending the name of the first wife, because your only issue is the first wife or second or third, which is which.
All right.
8,
the pension, it is made clear that as the petitioner had retired on such and such date, it date to the other. And almost so much, how much month have gone?
22,
When did you retire?
31/10/21.
21,
2020,
21
21.
provision.
Taking into account that the
17, 18.
almost 17 months, no, almost 2 years, no, it's, more than a year have already passed by. This court directs the respondent authorities to release the pension of the petitioner as expeditiously as possible and not later than 3 months from today.
Much appreciated.
Yes.
Made clear. So this is non-payment of arrears salary. The petitioner was retired on 31/12/2019. Thereafter, the authorities forwarded the arrear proposal in
You retired when?
31/12/2019.
And this is the area salary for which period?
From 2012 to 2018.
And why were you sleeping all this?
No, Malad, we have authority and authority, Malad, and the proposal to the DSC, and that was pending, Malad. Kindly see the last communication, Malad, that page, Malad, 35.
Page?
35, Malad. This was the last communication. The Deputy Director of Secondary Education.
Then
Malad,
also almost 4 years have gone.
Malad,
Then
it is 12. Malad, she is a lady, Malad, she cannot move Malad, from Thrissur to Malad, Korimganj to Guwahati, Malad.
so
all
we
the time.
applied the law differently.
Malad, in that letter, Malad, they query and they ask to.
Anyways. Heard Mr. T.K. Das, the learned counsel, appearing on behalf of the petitioner. Mr. N.J. Katoni appears for the respondent number 1, 2, 3,
4,
4,
5,
5.
6.
Why are you
7,
making director of elementary education twice?
Malad,
There are two
Initially-
director of elementary education.
initially, Malad, he was in a primary school, primary.
Understood, but why a same party twice?
Malad, Director of Secondary Education and Director of Elementary Education.
Where is it? 5 and 6?
Sorry, Malad.
Yes, Mr. Katoni, am I looking it wrongly?
No, Malad, yes.
5 is
It should
director
have
of
been, Malad,
elementary education.
secondary, Malad.
Second is also director of elementary education. 6?
Malad, this may be Malad problem.
Amalgamate. The school has let on amalgamated, Malad. That's why it should be director of secondary education.
No, there is there. Number 2 is there.
Oh, yes, Malad.
That is what I am saying.
This is a repetition, Malad.
That's when they appear for respondent. And what is the difference between 4 and 1 and 4? You want to give more copies to the government?
Malad, the 4 is Elementary Education Department.
So
Sir,
there is
in
different
2000
secretary for elementary education.
In 2012, Malad, she was in Elementary Education. Malad.
Mr. Counsel, it is all under the education department.
Yep.
You may have a director of elementary education, all the others are different. But as of now, there is only one.
Under DSC. Malad.
Now the problem will arise tomorrow. Where how can he accept notice on behalf of this person? This is a non-existent number 4, isn't it?
Yes, Malad. It is a Department of School Education and Department of
Actually,
Secondary.
it is school education. It is number 1 is already there. And how many more you have made?
Malad,
Why you are making the principal?
Malad, principal of the school. Malad.
Why?
Malad, he is Malad, forwarding agency. Malad. He forward the proposal. Malad. The principal forward my proposal.
Who pays you?
Malad, DSC. Malad.
Isn't it the Mr. Katunia, the BEO?
Yes, BO has already issued a non-drawal certificate, Malad.
So that is why
Yes, ma'am.
why 11 is required.
Otherwise,
You
not
want the
because-
money, or this case should be pending for another 10 years.
No, Malad, I want the money. Malad.
Then why you are making unnecessary people as parties? Heard Mr. D.K. Das, the learned counsel for the petition. At the outset, the learned counsel for the petitioner submits that in the writ petition, the respondent number 4, 6, and 11 have unnecessarily been impleaded, and as such, the same may be struck off. The registry shall accordingly, in that view of the matter, the names of the respondent number 4, the respondent number 4, 6, and 11 are struck off. Mr. NJ Khatuni appears on behalf of the respondent number 1, 2, 3, 5, 7, 8, 9, and Mr. R. Babudari appears for the respondent number 10. Issue notice making it returnable on area salary,
Yes, sir.
making it returnable on today is 17. Nah? Can we get some instructions by 3rd? By 3rd of April 2023. As the respondents are duly represented, extra copies of the writ petition be served within the course of the day. The case of the petitioner herein is that the petitioner is entitled to the area salary of rupees 9,20,883. Which is the salary as have been mentioned in the non-drawal certificate, Annexure 15 to the writ petition. It is the further case of the petitioner that the respondent authority more particularly the deputy inspector, the respondent number 8 and 9 have also sent proposals to the concerned respondent authorities for payment of the area salary. However, nothing has been done for the purpose of ventilating the grievances of the petitioner, for which the instant writ petition has been filed. The Learned Counsel, appearing on behalf of the respondent education department, both as well as the for the respondent education department, shall apprise the court on the next returnable date as regards the entitlement of the petitioner, and if the petitioner is otherwise entitled to, as to when such area salary shall be disbursed.
Right. Public.
9,
Yes.
May I obtain lordship? Had a petitioner retired as assistant teacher on superannuation lordship in 33/2016 lordship. His pension
You retired when?
33/2016 lordship.
13/3/2016.
16
13
16 lordship.
1/3/2016.
30 30
30.
lordship.
Okay, now what has happened? Why you are referring to Rafiq Masi?
Lordship, objection raised by the director of pension lordship
Ah,
at page 18 lordship.
why you are not challenging that? If you don't challenge it, what can I do?
Lordship, fixation of his scale lordship, that may be wrong lordship. I am not on that. Their objection is that I was given regular pay from the date of joining without passing basic training lordship. But lordship, they have made recovery statement lordship.
Then
But then Lordship, pension papers were returned back to the district Lordship. A recovery statement was prepared, has been prepared, Lordship. An amount of rupees 3,79,610 rupees, Lordship.
they want to recover from you.
Yes, Lordship.
But why you are not challenging it, Mr. Counsel?
Lordship, they cannot recover. Lordship, here, so my humble prayer is that Lordship, recovery is not permissible as per Supreme Court judgment, Lordship. Without recovery, they may finalize the pension of the petitioner after verification in the right scale. Whatever is that, Lordship. Delay is the main thing, Lordship. They have doing nothing, Lordship. And no way they have said that they are going to recover. They have made the statement, Lordship. In the communication, Lordship, it is not reflected that they are going to recover that amount. And Lordship may see the last
Then why you are into recovery business? Then?
Lordship.
Why you are saying anything about the recovery? If they are not going to recover.
Lordship, recovery is, they cannot recover. Recovery is not permissible, Lordship. As per Supreme Court judgment here, Lordship. And my humble submission is that if they may finalize my pension, Lordship. Without recovery, they may finalize my pensionary benefit, Lordship, in the arrears. And Lordship may see the last annexure, Lordship.
I've seen all your annexures, Mr. Counsel, but the problem is, yeah, it's okay.
Right.
But if this court doesn't touch on the question of recovery,
Right.
you will land into more problems later on. Do you understand this?
Right.
You want this court will set it, direct them to resubmit. The moment it is done, they will do it. Then from your DCRG, they will deduct this amount. Then you are again going to come to this court.
My prayer is there, Lordship. In the
Where is your prayer?
in the prayer I have mentioned, Lordship.
Where is your prayer? That is what I am asking you.
In the prayer, Lordship,
Yes.
is commanding the respondent to forthwith release the pension and pensionary benefit of the petitioner under the provision of Assam Services Pension Act 96 immediately without recovering any amount from the pension of the petitioner and on cause or causes.
Heard Mr. P.K. Raj, the learned counsel appearing on behalf of the petitioner. Mr.
And for one.
Mr. N.J. Khatuni
For one
appears
only,
for a response number 1.
Only one, my lord.
1.
225
BTC,
BTC.
Miss R.B. Bora appears for a response number 2, 3,
4 and 5.
4,
And
and 5. Mr. S.R. Borwa appears for response number 6, 7. Mr. R. Pujari appears for response number 8. Yes, Miss Bora, what do you say? When can you get your instructions? When can you get your instructions?
2 weeks.
Issue notice making it returnable on 3rd of April 2023. As the respondents are duly represented, extra copies of the writ petition be served during the course of the day. The case of the petitioner herein is that the petitioner retired on 30/3/2016. Thereupon, his pension papers were forwarded forwarded to the Director of Pension. The Directorate of Pension, the Finance and Accounts Officer from our Directorate of Pension, by the letter dated 15/11/2017, had mentioned that there was an excess drawal by the petitioner on account of wrong fixation And as such, by the communication dated had retired on so and so, pension papers were sent. The Director of Pension, by the communication dated 15/11/2017, intimated the Deputy Inspector of Schools, Buxa, that on checking the pension proposal of the petitioner, a deficiency had been noted, stating interior that although the petitioner passed the basic training during 2004, but he was allowed to draw scale pay from the date of joining, that is 1/10/1999, ignoring the conditions of passing the basic training. Under such circumstances, the pension papers were returned for necessary correction. The Deputy Inspector of Schools, Buxa, after receiving the pension papers, forwarded the same to the Block Elementary Education Officer, Buxa, for necessary correction, and thereafter, the Block Elementary Education Officer prepared a statement of pay, due and drawn by the petitioner since 1/10/1999 to the date of retirement, and found an overdrawal of rupees 3,79,610. Accordingly, the same was thereafter submitted to the Director of Pension after a period of 6 years. Thereupon, it was submitted to the Director of Pension. After a period of 6 years, the Director of Pension further issued another communication dated 6/1/2023. To the Deputy Inspector of Schools for resubmission of the pension papers after taking necessary action by identifying the person responsible, which led to the wrong fixation, leading to excess drawal by the petitioner. It is the case of the petitioner that the wrong fixation of the pay was not done. He had no role in the same. Taking into account the above, the learned counsel appearing on behalf of the respondent number, appearing on behalf of the BTC, shall apprise the court on the next date as to why the petitioner for the BTC as well as the Director of Pension shall apprise the court on the next date as to why the petitioner's pension have not been finalized till date.
Kindly come to annexure 2, my lordship. Annexure 1, I was worked as clerkship. Then annexure 2, my lordship. Then I was officiated to the post of page 12 and 12A. Annexure 2. Then to the officiated to the post of pump operator. Since then, I was regularly working to that post, my lordship, till 2021, and I was superannuated in the year 2021, my lordship. But till now, I have not got any pension. I have already submitted my. Similarly situated person have also already got, my lordship. And kindly come to page 13, my lordship, annexure 3.
You have been regularized.
No, no,
Annexure 6. How can you get pension if you are not regularized? You want the regularization in terms with the 20 years business as a government servant,
34
not in
years,
confirmed post.
34 years. 34 years in
Understood? But you want regularization under what means you want the pension under what provision?
Assam.
That I know, the rules of 1969. But under what provision? Means how? You are not a government servant. Are you a government servant?
Yes, my lord. Because I was sanction post. I was being appointed under sanction post.
Is it so? Where? Where?
Annexure 2, my lord.
No, where? No, Annexure 1. Where is it? That you
Annexure
have been
2.
appointed against the sanction post. You have been only asked to officiate as per 1992 order. Officiating is different.
But my lord, similarly situated. my
Similarly situated. But can this court review? Yes, the court can grant you in terms with that circular. There is a circular,
Office of
after
Annexure 3, my
completing
lord.
30 years, 20 years. That is another aspect of the matter. Where similarly situated cases has happened? Yes.
Now
Where?
I want regularization, my lord. Now.
Now you want regularization.
And pension.
Retrospectively. I mean, retrospective. But isn't it regularization, the concept of regularization is to regularize irregular appointments? Were you appointed by following the due procedure? Can there be a regularization of an illegal appointment? Yes. Or what? Was I arguing on your behalf?
No, Lord. Lordship, first he has to be regularized, Lordship.
Huh?
And moreover, finance is also not a party here, Lordship. There will be financial.
Don't worry, we'll make the finance the party. That is another thing, but you say, let's hear the finance without the finance being made a party. Yes, ma'am. Here is a case, the petitioner doesn't seem to be appointed against a vacant post. Officiating in respect to a post doesn't make his post against a vacant post. It's just officiating. Now thereafter he continued. What is the name of the petitioner?
Baharuddin Mazumdar.
Following departments are hereby allowed to officiate. Then they have a regularization of 2013. Benefit or protection of interim order have been engaged against vacant post and who has requisite qualification. So, were you engaged against vacant post?
In fact, when I was officiated, my lordship, that
Huh?
how far I know, my lordship, I apologize, how far I know, when I was officiated for that post, that was vacant.
You were?
When I,
You were officiating.
no. When when I was being officiated as a farm operator, my lordship.
The officiating is different. A person tomorrow, what is officiating? You have been only asked temporarily to hold a particular post. Isn't that? If I'm not wrong.
Yes, my lord.
If that be so, what is your right? Was the appointment at all held in terms with a particular advertisement? Was it against a vacant post? No. Then how do you apply this office memorandum of 27/6/2013?
In fact, my lord, this 27/6/2013 was challenged, my lord. And the honorable single bench, my lord, that my lord set aside this one. Against that, my lord, state went in appeal in Upenda. And therefore, my lord, Upenda.
So they were given 10 years. Person having in non-sanctioned post. So they were only entitled to be given the minimum of scale of pay.
Minimum, nothing beyond that. Because other decisions, Sanjita Roy and all those will come from the date of regularization. Here is a case, my lord, there is no regularization per se. Of course, the administrative department, it is there to comment. If at all there had been any regularization, but my lord, from the materials annexed to the writ petition, but it appears that he was not regularized because just working. Decision. There cannot be any retrospective regularization. There cannot be any retrospective regularization. Supreme Court is clear.
That day, Mr. Barbugai, I was looking into that another very important aspect has developed, which was initially not argued by any of it. And that I could come to learn from reading another case. See, that thing is, you deal with human. I deal with a variety.
Yes, my lord. Yes.
A very interesting thing came to light in one of the matters where Mr. B. Gogoi was hearing. I think Mr. B. Gogoi, yes. And on the other hand, Mr. M.H. Rajpal was. These were the people who were appointed initially in a corporation, irrigation corporation.
Corporation. Yes.
Into something around 2000, May 2005, these people were all given appointment letters, wherein it says that they will be entitled to the new pensions, old pensions.
Old pension.
13th of May 2005.
13th of May. Yes.
They were saying that they will be getting old pensions. Then a problem arose. How will they get it?
Yes.
Although the order was there, circular was there, the government's circular, everything was there. Then interestingly, the payment was all along made by the government. This is the third condition of 31.
Yes.
But condition number 1 and 2 had to be there, that he is in government service, permanent and substantive. Now the governor can override that in view of the proviso. And the governor overridden that aspect by issuing an order.
In favor of the
And thereby they were given the benefit of the past service. You see, how do you get the past service? Unless he qualifies, he doesn't become the government service. As you have placed the judgment in permission under.
Yes, yes.
If you see in one paragraph, I think paragraph number 24, if I'm not wrong.
Yes.
And in paragraph number 18, the terms of appointment were there.
Yes.
And the Supreme Court says that how is it possible that the past service can be taken into account if they were not at all in government service? Yes, it can be done, provided the governor overrides that.
and that too in case of exceptional hardship. The-
Whatever may be,
Yes.
that is 67.
Yes.
But 31, the governor can do it.
So the provision is there.
Now, the another aspect comes in as to whether the government, by way of a resolution, override the terms of the statutory rule.
Because if that appointment order in that case, my lord, which my lord is referring to, it is post 1/2/2005.
That is another thing. But if you see the application that the past service has to be taken in drop teachers,
Yes.
can it be taken into account without they being in government service? Yes, that can be done. But can the governor, without the governor doing it, can it be done by a resolution?
Because that will be in conflict with the rules, my lord, 59 rules. And most
And
of my
if
lord-
you see a very recent judgment of the Supreme Court delivered on 15th of March 2023 by Justice Kaul,
my lord,
will say that by way of a government resolution, the statutory service rules can't be amended.
Yes.
This is the latest one.
Yes. It cannot be overridden by an executive case.
Not on executive instruction, even by a resolution of the
Yes.
government.
Because statute, my lord, it is a creature of the
Now,
legislature.
what you have done in Jivan Deka's case? In Jivan Deka, what you have done is, you have taken, the government has taken a resolution, we'll take the service. Can it be done without amending the rules or without the governor? Because while reading that paragraph 18 and 24, I was just thinking, how is it possible? Why did the Supreme Court say so?
Yes.
There has to be some rational or some logic behind it. The logic is this, and this I got it in some other case out there while looking into it. Yes, so that is the reason why the governor passes the such orders.
Yes. And there comes the issue of my lord, pensionable and non-pensionable establishment.
No, forget about the pension because Rule 31 does not say about pensionable or non-pensionable. It says about first, he has to be in government service. Admittedly, these people were not there. Number two, it has to be permanent and substantive. And permanent and substantive, you have to read it with the government service.
Yes, government.
It
And
can't
that-
be anything else.
Yes, and
Not
that-
like the case out here in the petition.
absolutely. And that has been clarified, my lord, in Obani Borwa, which we have given. My lord.
And the number three, they have to be paid by the
Yes,
government.
yes.
Now, can you say that by virtue of the orders passed by which the court has directed on the question that you have taken the services and payments being made, would it constitute the same condition in terms of three?
Yes. It will mean,
Will be very difficult.
because there cannot be, if there is any conflict between, my lord, action of the administrative action,
So can't we say
vis-a-vis the,
that the horse 2A being not taken into consideration by various courts?
Yes.
31 was not taken.
31 was. And that case which my lord is referring, appointment is post 1/2/2005. So rule 2A will come into.
Forget about 2A.
Yes.
Let us not take into 2A. 31 was not taken.
Yes. 31 is otherwise clear.
No, if 31 is not taken into inquiry, wouldn't that be a case of per impurium? That is why it is taking a long time to deliver the judgment. Otherwise, I don't take so much time.
Because then there will be a melody, so whether 141 will apply, because law laid down by the Supreme Court, 141 of the Constitution, vis-a-vis, my lord, the action of the government, as well as, my lord, in the face of the existing statutory provision, that is Rule 31. So three aspects of the matter have to be reconciled.
No, 141 is okay. But the question of, if you see that you are relied upon the judgment in Kotak Mahindra.
Yes.
Kotak Mahindra, the per impurium aspect is there in Jolly Burgess.
Yes, so from Jolly Burgess, it has been, yes.
Yes, but in Kotak Mahindra, a very important thing has been mentioned out there in paragraph number 64. then if one fact has changed, it cannot be said to be a ratio any further.
Yes.
The fact which has changed is the policy decision.
Yes.
So you can't attach finality to Jiban Dekha.
Because
I'm just
no,
exploring.
my lord, yes, yes, my lord.
I'm keeping on exploring
My
what
lord,
is,
every day is a learning because
because it is very difficult otherwise, because you have to meet. There are so many judgments,
yes,
and the government have allowed everything to attain finality. Yes. But how do I help you, madam, Mr. Counsel? How do I help you? How can you be regularized if your appointment was irregular? Not irregular, illegal.
Can Lordship look at annex?
Hmm?
Just for it, annex 6. Annex 6.
In excess 6. Chalo. Your name doesn't appear here.
Serial number 7.
7. This is written by the executive engineer to the chief engineer for regularization.
Similar
Is he an authority to do that? Who will regularize you? Huh?
Government.
No. Then
He said that similarly situated.
I'll take up your matter again. Not today. Today is what day? I'll have it on Monday. You go through two judgments. One is Uma Devi, 3. And the other judgment is the, that was, what was that? 2018-19 SEC, Justice Chandrachud's judgment, Chief Justice Chandrachud's judgment. That was in the case of the matter which went from the High Court. From the High Court, the matter went to the Supreme Court. To the effect that the orders were passed by the Jammu and Kashmir High Court.
Yes.
Which was the judgment?
my lord, that is
2000. That is the where the concept of irregular illegal appointment concept has been given, no?
my lord.
Following Renu.
Yes.
I gave you that judgment while
Yes,
hearing
yes,
that matter. I think 2018-19. Give it to him. Leave it on Monday. Read it.
My lordship, with due respect for submission, can it be after 31st of March?
Why? Financial year
No,
has to end.
my lordship, I have exam. I have exam.
Okay. Very well. You have exams, then you should be given some liberty. Let's have it on 3rd of April.
Highly obliged.
At the request of the learned counsel for the petitioner, let the matter be listed again on 3rd of April 2023. You go through these judgments and find out if anything can be brought out. And why not? You will be entitled to the benefit of, tell you one thing. Try to make out a case that you come within the benefit of the 6th September 2003 office memorandum. You have this book?
Yes.
Page 190.
That is my lord, 2017 3 SCC 410.
That is Justice Thakur's judgment?
Yes.
No, not the Justice Thakur's. Justice Chandrachud's judgment.
Yes, Justice Thakur, Justice Chandrasekhar Nageshwar Rao, my lord. Yes, Jammu and Kashmir versus District Bar Association, Bandipora.
Yes. Give it to me. Take that citation. Read it.
2017 3 SCC 410.
Read it. Then you come prepared on 3rd after your exam.
For admission, part hard item 48 from supplementary.
Yes, health.
May please reverse.
Yes.
Amar Kitto.
Why is this parted? Who says
Ordered by
parted?
your lordship had passed an order
Ah,
directing us to file an affidavit
ah.
with the donor on 16/2/2023. Your lordship will see that order.
Yes.
And we had filed
Counsel
an
appearing on
affidavit.
behalf has submitted it in the paragraph comments which have been submitted as well as placed by the learned senior. That there are sufficient number of doctors in the department. There is 2 doctors either. 2 doctors. Oh, that matter.
That
I
matter,
remember.
transfer matter.
Where
the
these
doctor.
people are for 15 years, these people are there.
Yes. I have filed an affidavit, my lord, and thereafter they took time to file a rejoinder to that one, but they have not yet filed.
Lordship, in this matter, Mr. P. Gogoi appears, Lordship. I have informed him, Lordship.
That thereafter the order, your lordship is 28/2/2020.
Then you are not interested in vacating the order. We make it absolute.
No, Lordship. Mr. P. Gogoi will appear, Lordship, in this matter, Lordship. Let him come. After some time, Lordship. After some time.
After puja vacation?
No, Lordship, after some time. After some time, at 2, Lordship.
No, no. You're not appearing. What is the item number 2?
48 supplementary.
Parted? Parted. There's no parted.
No, it was not parted, but
No,
they
no,
have
it's
shown
not
it.
parted. Because there is another matter. We'll take it after some time. You just ask him to come over.
Yes.
You mean like you have matters in the second half?
No, I don't have it. Matter.
So we'll take it up before 1:15. You wait. We'll
Yes,
take it. We'll take it up
I-
before 1.
Right, sir.
What?
Number 12.
There is a pension matter, my lord.
Hmm.
Maybe the husband died in 2017, my lord. Since then she has been running after male pension, my lord. Till date, nothing was done.
What are you asking for? Writ of mandamus directing us to regularize the period of suspension of the petitioner
Yes,
and also to release his family pension to the petitioner,
petitioner's
including
husband, my lord.
areas due to her husband
Yes.
from the date of retirement to the.
Lordship, we will file a affidavit, Lordship.
What
And on
does
the
it say?
last date, Lordship, the last order, Lordship, 2/11/2022, Lordship. Lordship, it was placed before the accountant general, all the papers, Lordship. We have stated that in our affidavit, Lordship.
Submission of family papers, family pension papers of 20. Now, what about his prayer for regularizing that period? Suspension period?
Lordship.
Therefore, we have returned back, Lordship. Since the suspension period was not regularized, therefore we return back with an observation to regularize the period of.
What have you done?
Lordship, that instruction I do not have. Lordship.
Why?
Lordship, because Lordship,
Isn't there in the petition itself written that to regularize? Isn't that
Yes,
the
Lordship.
prayer?
yes, Lordship,
Then?
that was the prayer, Lordship. But Lordship,
He retired when?
in Lordship 2017, Lordship, sorry, Lordship, in 2013, 1st October 2013.
My goodness, he has not got his pension. And he died also
Yes, Lordship. He was placed under suspension, Lordship. Then he expired on 2000.
after his retirement.
Yes. Lordship,
After his retirement or before? Suspension?
before, Lordship.
That means it has been before 2013.
Yes, Lordship.
2007.
My goodness. 10 years have gone by.
Lordship, I'll get that instruction whether he was regularized or not, Lordship. If not, Lordship, he will regularize, Lordship. Because we have submitted the papers, but if we have not regularized, Lordship,
Heard Mr. R.P. Sharma, the learned senior counsel, assisted by
Yes, Bhashya.
so and so. Mr. D. Upamanyu appears on behalf of the Health and Family Welfare Department. Health and Family Welfare.
yes, Lordship.
Now it is, I use homeopathy college.
And Mr. Ardhor appears on behalf of the
That's what number 6.
Accountant General AE. Mr. Ardho, the learned counsel appearing on behalf of the Accountant General AE submits that the pension papers of the petitioner could not, the pension papers of the petitioner, the family pension papers of the petitioner, as well as the entitlement of the husband of the petitioner could not be finalized in view of non-regularizing the period of suspension of the husband of the petitioner. It shocks this court that the husband of the petitioner had retired in the year 2013. Until date, neither the husband of the petitioner, who expired on
2017.
16 March 2007.
16th March 2017, nor the petitioner thereafter have received the pension, arrear pension, pensionary benefits, as well as the family pension, even after a period of a decade have passed pursuant to the retirement of the husband of the petitioner. The learned counsel for the Health Department shall apprise this court on 31st of March 2023 as to whether the period of suspension of the husband of the petitioner have been regularized.
13.
Item 48, my lord.
Yeah.
It be after a week, my lord. They filed one additional affidavit bringing to record certain, my lord, details of 5 subdivisional medical health officers who are senior to the petitioner and they are working in Goalpara. On
For the
that
last
point,
15 years.
my lord,
Last 15 years.
no, my lord. They have been promoted in 2021, 20, like that, my lord. It's not that, my lord, as a, my lord,
No, you see,
subdivision-
why this court stayed it then
my lord.
is because of the fact that there were some, you have brought in. Yes, the one thing aspect is there that there was some your case is that you have committed some
Yes,
mistake.
it's not that by
In fact, he should not have been brought out there to which place? Gwalpara, Gopur,
Hosai.
Huzai.
Instead of Goalpara, Hosai.
He should have in fact been sent to Gwalpara then. But the petitioner's case is that there are already 5 persons who are working there,
Lordship.
and of which 3 have been working there for the last 15 years, but you have not done anything. And you have just picked and choose the petitioner. for that.
Our reply is, my lord, that inadvertently he was posted again in
No,
Goalpara.
that I have got it. But the question, therefore,
My lord.
as to whether it's a case of pick and choose.
Yeah.
Because if you have allowed somebody to, because your basic reason is that he should have gone to Gwalpara, not to here, because of the fact that he was there for the last 6-7 years earlier.
2010, no.
2010 or maybe 6-7 years earlier. But he says that forget about 2010, which I was there or whatever may be. There are people who are there for the last 15 years, you have not taken any action. And as such, it is a case of pick and choose, abuse of the powers, isn't it?
It was, in fact, my lord, I have found 2 persons among them who are there in more than 25 years. One was 28 years, the other one was 29 years.
So I will have the inspection, my lord. But otherwise, my lord, he cannot point out that, my lord, this should be, so and so should be transferred, not me.
No,
Being
no,
employee,
he
my lord,
cannot. But he can very well say that if there is a pick and choose,
that, my lord, from the records will reveal
Then,
whether
obviously-
deliberation was made or not. It was not a transfer, my lord. It was a promotion posting. Inadvertently, after the promotion, he was posted in, my lord, Goalpara instead of Hosai. And in Hosai, my lord, there is no, my lord, deputy superintendent or the subdivision medical health officer. That post is vacant. So, my lord, we have posted it.
understood.
Might be, my
Inadvertently
lord,
is
he
another
is
thing.
more efficient,
But
my lord.
if
Amongst these, my lord,
because
he is more efficient.
initially when you started your case,
Lordship.
isn't it that this person was there from 2010 onwards? Why not he should be? Therefore, it was inadvertent.
Yes.
No, return instruction says, my lord, that at the time of promotion also, inadvertently, my lord, we have again posted him in Goalpara.
Understood.
Should not have been.
Shouldn't have.
And other persons, they were promoted in
Anyway, you
2021.
file your affidavit.
I will file my affidavit.
Mr. B.C. Das, the learned senior counsel, assisted by
Assistant.
and Mr. P. Gugoi, the learned senior standing counsel for the Health and Family Welfare Department, who submits that he requires an accommodation for a week for filing the affidavit. list the matter again on
28, my lord.
28.
Can be, my lord, not dotted out.
28, why? Tuesday?
It can be hard, my lord. Take up, my lord. They will also place some judgment, my lord. I will also like to place some, my lord, otherwise.
Okay, 28th of March 2023. The petitioner, the respondent shall file the
Can it be on
affidavit
29th?
by 24th of March 2023.
Well, can it be on instead of 28? Can it be on 29th or 30th?
Yes, my lord.
30.
Liberty may be given, my lord, to mention in my lord.
30.
Fix it at
30.
30 and the respondent in the health department shall file the affidavit without fail by 27th of March 2020.
Yes.
Liberty is given to the parties to mention the matter.
I'm obliged.
It will be already there.
Yes.
Interim to continue.
Oh, the interim order passed earlier shall continue.
My lord, in item number 13, I'm appealing for the respondent 2 and 4, Public Enterprise Department. They have filed an IA, but we have not received the copy. And even otherwise, my lord, we have filed an affidavit. We'll file an affidavit during the course of the day.
What do you want?
My lord, matter may come up after the affidavit comes on record, my lord. We'll file it.
When did you file?
My lord, we tried to contact on the last date itself, but we have not been able to contact. But now my senior friend is here. We'll file the affidavit today itself.
You want to give him a copy?
My lord, we'll give him a copy and we'll file
You're
it.
filing it today.
Yes, my lord.
Your name?
RB Goswami, my lord.
Mr. R.B. Goswami, the learned counsel appearing on behalf of the respondent.
2 and 4, my lord.
2 and 4 submits that the affidavit to be filed by the said respondent is ready and would be filed during the course of the day. That the matter be listed again on, what is the matter?
My lord, PRS scheme employees.
My lord, please, this is a matter of the voluntary retirement and retirement benefits, my lord. This is the credit petitioners, the employees of the Assam State Plantation Development Corporation Limited under the administrative control of the Soil Conservation Department, now amalgamated with the Industry and Commerce, my lord. And they have applied for voluntary retirement because their pay has not been revised since 1996. Then that was the 5th pay commission. Then after that, since that year, they are continuing in the same meager pay scale. So they are not willing to serve more. So they have submitted voluntary retirement application, my lord, on 21st July 2021.
Okay, we'll have it on, we'll file the affidavit. We'll have it on 26th of April. This is the matter again on
My lord,
26th of
I'm
April.
appearing for respondent number 1, 3, and 6, 7.
Your name?
RS Deuri, my lord, for soil
R.S.
conservation.
Huh?
For soil conservation department.
Or R.S. Duri appears
My lord, a copy of the
for the Soil Conservation Office.
And my
Department.
affidavit has been filed, my lord.
My lord, we
Who
have not-
submits that the said respondent have already filed. This is the matter again on 26th of April along with the said.
my lord, a copy of the IA may be provided, my lord.
Why? What I?
There's an IA, my lord. They have filed.
You,
Complaint.
16.
Right.
Hmm.
The matter relates to the non-payment of salary lottery after regularization lottery for a certain period lottery with effect from 2006 to 2008. They have not been paid salary. Although the matter has been under process, but from the regulation order it itself says that from the date of joining, they will get the.
you want the salary for 15 to 2006 to 23 for
Yes.
2008.
That is from the date of regularization till the date of readjustment lottery. Lakshmi kindly come to pay. Number
Mr. Dekka, why have you come so late?
all along the matter has been under process lottery. I have annexed those internal documents. Proposal circulate lottery twice price lottery.
Have they anywhere stated recently that you are
Yes,
entitled
in
to?
2021 also lottery kindly
Where?
come to pay.
I'd
Page
like to complete
number
the report regarding
46.
payment of arrears salary to
This is from the
people who
director to the
adjusted.
DO regarding payment of area salary in respect of so reference has been given all the letters. Prior to also the matter has been under process. Now by this
Payment
letter,
of
the
arrears. What is your name?
Sajal Das.
was all that.
His name is at the regularization order, Lordship find at position number 109, page 26. This is the list of officer for regularization under cabinet. The name of the petitioner is at Lordship find at page 26, serial number 109. Thereafter, regularization order issued.
Yes, Mr.
Yes,
Katunia,
yes,
why-
sir. I have received an instruction from the director, my lord. The earlier the proposal was sent by the my lord, district elementary education officer Bongaigaon, my lord. But subsequently the school was amalgamated with the high school, my lord. So now a proposal has to be sent from the inspector of school to the director of secondary education, not the elementary education. So in fact, secondary education is also a party, my lord. I have received the instruction from the elementary education. So my lord, may give me some time, my lord. I will obtain instruction from the director of secondary education, whether that proposal has been resubmitted or not, my lord.
Who is going to?
Inspector of school.
Inspector of schools comes within you.
No, director of secondary education, my lord.
That's, you are appearing for
Yes,
them.
yes, I'm representing the director of secondary.
So you take it up with these people.
Yes, madam.
Why they have not done it?
Yes.
When it is an admitted fact that this amount has to be paid to the petitioner.
Yes.
Well, I don't understand. And it doesn't look nice that a person has not got his area salary from 2006 to 2008.
Last occasion, Lordship, Henry Johnson submitted a message under process. Within a short, the last occasion, I forget the date, Lordship. Mrs. Anne Pukonsi submitted that the matter is under process and in this short period of time they will get.
They would say, now we have made it clear now.
Sure.
Heard Mr. A. Deka, the learned counsel, appearing on behalf of the petitioner, and Mr. N.J. Katunia appearing on both for the elementary is a
Yes.
party,
Yes, yes.
Yes, yes, madam.
secondary is a party,
Heard, Lord.
both appearing on behalf of the elementary education department as well as the secondary education department. From the materials on record, it appears that the petitioner have not received the salary for the period from 15 to 2006 to 23 for 2008. It further appears from the records that the authorities have been writing to, there has been interdepartmental communication to the effect that the petitioner's area salaries should be paid. Mr. N.J. Katunia, the learned counsel, appearing on behalf of the petitioner, submit a respondent. Submit that the petitioner initially was under the elementary education department. Upon amalgamation of the said school with the high school, the petitioner services came under the secondary education department. He submits that he may be given an accommodation for 3 weeks so that he can obtain the necessary instruction as to whether the proposal has been sent again by the inspector of schools of the secondary education department to the director of the secondary education department. In that view of the matter, let the matter be again listed on 12th of April, 12th is the last day, 10th of April, 2023, on which date the learned counsel appearing on behalf of the, appearing on both on behalf of the secondary education department, on which date Mr. Katunia, N.J. Katunia, the learned counsel shall obtain the necessary instructions and apprise this court. Liberty is given to the petitioner to mention the matter for upgrading.
Lordship, if necessary, the inspector of schools Bongaigaon may contact with the district elementary education officer of Bongaigaon because some materials may be required from the district.
Mr. Counsel, why should this court go into these nitty-gritties about these people?
Last second, there
It
might
is
say,
for the
Lordship,
inspector to give the proposal, let them do whatever it is. It is apparent that you are entitled to. On account of these interdepartmental proceedings being delayed, it doesn't help it. If the matter, this court is still sitting in the same bench, you may be fortunate to get the order.
Okay.
22. Yes, Mr.
In
Majumdar.
this case, I am appealing for a response. My lord, I have received the instruction from my mail, my lord. I need 4 weeks time to file the affidavit, my lord.
What is your case?
My lord, the petitioner was given 4 reading entries
4 red ink entries in the Assam Rifles, my lord. And thereafter, only on the basis of those 4 red ink entries, he has been discharged
Set
from his
aside and
service.
quash the impugn order of the charge.
My lord, he has been discharged. Normally, the Honorable Supreme Court has recently settled the issue that mere presence of the 4 red ink entries would not make a man liable to be discharged from the service. The reason why after that 4 red ink entry he is still to be discharged has to be recorded by the respondent. That has not come up in that order. He wants to file an affidavit, my lord, maybe he can bring on some record.
Heard Mr. K.K. Parasar, the learned counsel, appearing on behalf of the respondent, who submits that he requires 4 weeks' time for the purpose of filing the affidavit. He further submits that he has already received the instructions. Let the matter be listed after 4 weeks on 8th of May 2020.
23. Item number 23.
Yes.
Sorry, Lordship, I have missed the case as because of my name not been shown in cause list.
Oh.
I'm TR Gogoi for Housing Board. Lordship.
You have
But
filed the
earlier
affidavit.
I have submitted the affidavit.
You have filed the affidavit.
Lordship.
And the petitioner is not there. Petitioner, has he got the money or what is the matter about? I reckon it should not be issued. I reckon compensation. And the respondent move in respect to release the pending retail dues of 7,79,000 with interest to the petitioner in a single installment within a specific time. So he's asking for some amount, 7,79,000. Why haven't you paid?
Lordship, due to acute financial condition, Lordship, we are ready to pay the outstanding dues in monthly installment basis. Lord.
Very well. Where is that petitioner, counsel? MH Loskor. Where is he? You could have got that order today in installment. Because I passed you, check it out in the warehousing matters. I have passed that order.
Lord.
Whereby I have asked them to get it out there in 1 year. In equal installment. But this is, what is the amount? Why? How did this amount of 7,79,000 happen?
Details I'm not remembering. Lord.
The amount of as claimed by the petitioner is correct. Oh. This is your prayer also.
Lord.
In your affidavit, you have stated it is further that in view of the poor financial condition, the board has decided to release the outstanding retirement dues of the petitioner within 12 months in equal installments.
Lord.
That is your prayer also.
Lord.
The respondent shall give an initial payment of 1,79,000 only out of the total remaining month as the first within 1 week, and thereafter 50,000 as well. So without the petitioner counsel being present, it becomes very difficult. Where is he? Petitioner counsel means. Hey, get hold of any of these. The phone number given.
Maybe fixed for Monday.
Now we'll list it after 4 weeks. You get another some more time. With the petitioner counsel. None appears for the petitioner. This is the matter after the PUP. You've got it.
24.
In the meantime, is the Gogoi accumulate the amount?
Lordship, may I please, Lordship?
Yes, what do you want?
My lord, petitioner for you, Lordship, my lord. Lordship, I am appearing on behalf of Lani Miss Rita Devi, Lordship. She is in another court, Lordship. The matter may kindly be passed over for the 4 weeks, Lordship. The affidavit has been sent for taking. My lord, already, my lord, long time gone, my lord. So, my lord, court date may be given as per earlier.
Mr. Counsel, whatever date, this court can't give you a date in the month of October, in April. Not possible. What do you want? Reinstatement.
Reinstated, my lord. But he was
You've been
removed from-
discharged.
He was constable, my lord, CRPF constable, my lord. My lord, he was, my lord, removed from, my lord.
Yes,
was
heard,
post, my lord.
Mr.
Yes,
J. Islam, the learned counsel for the petitioner, and Mr.
A.R. Tahbildar.
A.R. Tabilda, appearing on behalf of the Central Government Council. He submits that the affidavit is already ready and have been sent for vetting and will be filed within a period of 3 weeks from today. Let the matter be listed on 3rd of May 2023. The respondent shall file the affidavit on or before 24th of April 2023. The petitioner thereupon, if so advised, shall file their reply.
Obliged.
25.
Wait. I was working as a statistical officer, my lord,
Hmm.
and I retired from service on 31/12/2019. After my retirement, my lord, the corporation extracted services from me for around 30 months. And out of those 30 months, my lord, only for 22 months they have paid. For the remaining 8 months, my
8 months you are entitled to.
entirely. Now they want to say that those 8 months will be considered as voluntary. Had they intimated me that my services would be considered as voluntary, I would have declined any such form of employment.
Lordship, the affidavit is ready. We need 1 week time, Lordship.
Mr. Shi Sharma, the learned counsel appearing on behalf of
Respond number 1 and 2.
Transport.
Yes,
ASTC. ASTC.
Yes. Submits that the affidavit is already ready and will be filed by the first week of April. Let the matter be listed again on 26th of April 2023.
Madam, I am appearing for response number 3. No
You have
extra
filed your
copy has
affidavit.
been- No extra copy has been served to me.
Okay, I'll give it.
I thought
3
so.
extra copies I'll
Extra
give.
copy.
Obliged.
Nowadays we are in live streaming. It doesn't look nice on the part of the petitioner.
I'll give it.
I'm with you of that.
29.
MD Bora appears for response.
I was directed to file my affidavit. There is delay in filing the affidavit. Today I have my first client has went to the petitioner to serve the copy of affidavit, but he had declined to receive it.
Who?
Petitioner.
No, my lord, affidavit is supposed to give before 14, my lord, but today is 14.
Mr. Counsel, why you are not doing all these things?
So, today
You
they
were
have-
supposed to file by 14.
Yes, sir.
Today is 17
Yes.
and you are not receiving it.
Before 14, my lord.
Very well.
That's it.
You don't want the affidavit.
Yes, my lord, my senior, I think.
We'll proceed on the basis that the affidavit has been
Okay,
filed.
okay, my lord, but this
And
honorable
I
court
will
has-
give him the permission to file it without you serving you a copy. Is it okay?
No, my-
Then you serve him a copy.
Lord,
Mr. Esbora, the learned counsel appearing on behalf of the petitioner submits that he will be filing the affidavit after serving a copy of the affidavit. Shall be filing the affidavit today during the course of the day after serving a copy of the same to the learned counsel for the petition. The petitioner is given 7 days. The petitioner is given 10 days for the purpose of filing a reply if so advised. Leaves the matter again on. What is the matter about?
because the education volunteers, their period of service has expired on 31st of December. The centrally funded scheme, and that fund has expired. Madam.
Oh, I have not passed a similar order. I remember. Oh, other courts have passed.
Other courts have come because one court has, because the
I
case come
remember, I
before prior to
remember.
his expiry.
Okay, we'll have it on 3rd of April.
Okay, obliged.
It's a matter on 3rd of April.
I will file it during the course of that.
Hmm?
I will serve him a copy and file it.
Take it. And you file your reply if you so.
Number 35 for orders.
Admission check. To Lulu, like, you know, the orders, nobody will be there. Petitions उनको yes, orders, none appears for a petitioner in court.
11.
What is the
Sorry,
orders?
35. Item number 35.
Why the matter is fixed? Why does it come for orders? To release the pay and amount of. You have got your instructions, Mr. Khan?
No, Lord.
Why? Pay the amount of transfer sanctioned by the order being the DCRG amount due to the demand as well as the post-retirement benefit due and benefit. Oh, then has he got anything?
The second day, Lordship, the inspection was not received.
Submit that the provisional DCRG amount has already been paid, given to the petitioner's husband, and accordingly, the DCRG would now be 43,000. Now, has he got the benefits?
Oh, no, Lordship, he has not present.
None appears on behalf of the petitioner on call. Mr. A. Chakraborty appears on behalf of.
So 1, 3, 4. 1, 3, and 4.
1, 3, and 4. Mr. Barbujari appears for the respondent number 2 and 7. And Ms.
J. Das appears
for the respondent number 6. The learned counsel for the respondent shall apprise this court on the next date as to whether the entitlement of the petitioner have been paid. Full stop. The claim of the petitioner herein is that the petitioner is entitled to the pensionary benefits of her husband with effect from 8/5/2018. For the DCRG as sanctioned by letter dated 14/8/2018, as well as for payment of the regular family pension. The petitioner have also sought for the service benefits of the petitioner's husband, including leave salary, GPF, GIS, etc. When a matter was moved on 17/3/2021, Mr. P. Nayak, appearing on behalf of the finance, had submitted that a provisional DCRG amounting to rupees 5,84,992 have already been paid to the petitioner's husband. And accordingly, the DCRG, remaining DCRG payable would be rupees 43,064. The learned counsel appearing on behalf of the respondent shall apprise the court on the next date, that is on 3rd of April 2023, as regards as to whether the petitioner is further entitled to any other amounts. List accordingly.
36.
If your Lordship, my senior is not like kindly matter my password of time.
What time being? There's no time being business out there. There's the respondents. None of the respondents are here. It has up to the notice of the existing letter. Let the matter be listed after 2 weeks. Your name, madam?
It's Takuria.
H. Thakuri appears for the petitioner. None has appeared on behalf of the respondent for court. This is the matter of 2 weeks.
37.
Yes, madam.
Formally raised that the petitioner is the wife.
Why the matter has come? Photocopies of the postal journal is marked.
The respondent number
Postal
7 is
service
the
is
father-in-law.
marked that no consignment is with- Service not complete.
Lordship deemed to be complete as per Lodima Court's order.
Okay. So the service upon the respondent number 7.
Yes, but the father.
Heard Miss R.H. Chaudhary, the learned counsel, R. Chaudhary, the learned counsel appearing on behalf of the petitioner. Miss R.B. Bora appears on behalf of the PTC. And Mr. P.K. Bora appears on behalf of the Elementary Education Department. It appears from the court order passed by the Lodima Court dated 13/2/2023 that the service upon the respondent number 7 can be deemed to be, has been deemed to be served. So, taking into account the same, the service is complete, and accordingly let the matter be listed before for admission immediately after the Bihu vacation.
38.
I, what I for what?
I for actually was for a specific
What do you want with I?
50% of the benefit it was for. Actually, they are the
ASIDC to pay
ASIDC,
up the retirement benefit subject to the condition that if the 50% exceeds the month, then he be paid 50% of his retirement benefit, and if the 50% is less than a month, then the remaining would be accepted. What is this IA main petition from now? Why have you filed the IA?
Well, I have filed in a similar case, 50 from specific fund, 50% order to release 50% of pensionary benefit to the similar situated person. I don't know whether that is available or not. ASIDC.
Lordship, we have been the newly engaged counsel. We have to receive some instruction from.
You received the instruction?
No, we have to receive instruction from our department. We newly engaged counsel.
When were you engaged?
Last week, your Lordship.
Oh, very well. You are in very good
We have
touch
to
with
receive
the
a brief
department now.
from the
So
department.
get the instruction by tomorrow, and we'll take it up on executive.
So that will be given. Lordship.
We will take it up on 24th.
Lordship.
Mr.
S.A. Borbuya on behalf of S. Das.
Your name?
S.A. Borbuya.
S.A. Borbuya.
Yes.
Appearing on behalf of the AS, what is that? Sorry, on
ASIDC.
behalf of the Assam Scale Small Industries Development Corporation Limited. Request for an accommodation for a week so that he can obtain the necessary instructions in the back. The learned counsel for the petitioner has submitted that in similar matters there, this court have already passed similar orders granting 50% payment of 50% of the retirement dues. Taking into account the same, let this matter be listed on 24/3/2023, on which date the learned counsel for the ASIDC shall obtain the necessary instruction.
Deeply applied.
39.
Yes.
Here in this matter, the petitioner's date of birth has been changed by the department if the employer pursuant. to
What
the-
order? You are
pursuant to
asking for
retirement.
modifying?
No, we have filed the IA challenging the communication by which the provisional pension has been granted. In fact, the petition, this arises out of.
No, madam, what are you asking for? Why are you asking for setting aside this order?
Lordship, to the extent of fixing provisional pension from the date what they've done is that pursuant to the petitioner's retirement, they have refixed his date of birth. They have corrected the service book pursuant to his retirement. While processing the pension payment order, they have realized that his date of birth should be this, and they have accordingly exploited. They have
No, you retired on 31/5/2020.
18.
13.
18.
No, here it has been mentioned as 13.
That is what we are challenging here. That is what I was submitting on. After I retired, while processing his pension case, they have refixed my date of birth. They say that date of birth ought to be 1/5 to 1953 and not 1/5/1958 as it appears in the service book. And that is why we had filed this writ petition. And pursuant to that, during the pendency of this case, they have refixed my date of birth and has issued this provisional pension.
Okay.
With effect from. That is why this IA has been filed.
Very well. Have they filed affidavit? So the main writ petition has to be decided.
Yes.
We
main
can't,
petition has-
but madam, only one thing. That order of granting you the provisional pension from this particular thing is only consequential to the writ petition.
But as nevertheless,
Means
have
if
to
we
challenge.
hold it that your date of birth has been wrongly fixed by 5 years, which have been done by this respondent, then automatically the consequence will be this IA will be allowed.
Yes. But
Hello.
we have to bring.
Now
it on
let us
record.
hear where's the government?
Government does not. There's a standing council of the Animal Husbandry Department.
Yeah.
It appears.
Who is he?
Some.
Okay, heard Ms.
We have some
D.
officers
Borgohain,
there.
the learned counsel appearing on behalf of the petitioner. Budagohain or
Borgohain.
Borgohain?
Yes.
Okay. Oh, your name is not there here.
The file was
None appears on behalf of the respondents on call. It also appears from the records that the notice was issued as far back as on 5/10/2020. But till date, the respondents have neither appeared, but till date, the respondents have not filed any affidavit in the instant matter. Consequently, this court fixes this matter again on 3rd of May 2023. It is made clear if no affidavit is filed, the court shall proceed to dispose of the matter on the basis of the available materials on record. List the matter for admission. Should come up for admission.
Lodge, yes.
The interlocutory application of that order that the heard Miss So and so, the learned counsel appearing on behalf of the petitioner applicant. The interlocutory application can only be decided upon after deciding. The decision in the interlocutory application shall depend on the decision in the writ petition, and as such, the instant interlocutory application shall be taken up for disposal along with the writ petition.
I don't know, 40.
I actually don't get a chance to get the what do you call this orders.
May I
Yes.
plead the lordship? Matter regards to non-payment of salary, my lord.
Now, why the matter has come up for orders?
Yes, my lord, in the
None
last-
appears has been made in respect to respond till today. Hence the matter is laid before the honorable court. Who is respond number 3?
Response number 3 is the chairperson Karimganj. We have given the dusty service as well as the,
Chairman, Karimganj Municipal Board. Do you have served notice?
yes, my lord, we have given the dusty service also.
Dusty has been done.
Yes, my lord.
Where is it?
We have filed. the
Yes, we have
application.
filed an additional affidavit. No?
Yes, regarding that. We have filed on.
Take
18.
notice that so and so. Who has received? Okay. Heard Miss
And Google.
M. Gogoi. N.
N.
N. Gogoi, the learned counsel for the petitioner. Mr. A. Chakraborty appears on behalf of the respondent number 1, 2, and 5. And Mr. S.K. Chakraborty
Yes, for respond number 4.
appears for the respondent number 4. It appears that the service upon the respondent number 3 have been duly completed in view of the dusty being affected upon the chairman Public Chairperson, Karimganj Municipal Board on 12/1/2023, and an affidavit being filed in that respect on 18/1/18.
Yes.
18/1/2023. Taking into account the same, the service upon the respondent number 3 is deemed to be complete. Let the matter be listed for admission on May 2020.
Inform. See, look here is your mandatory period is over. What do you want to say? Mandatory period. This is the duty of the court to inform. Now, if the period is gone, now suppose the period of 100 days, he doesn't exercise. Then he cannot come back. But 436A, that the indivisible right will continue. That's the difference of 167(2) and 436A. And so far as my lord, I'll just point out, if the lordship allows me, one judgment of this Supreme Court Manu Bhai. Trial court actually, how the trial court should determine? Because there are a number of cases, how the trial court will know, that's what your lordship's query was there. But to that extent, kindly look into one judgment of the Supreme Court. 2013, 1 SCC, page 314. 24 to paragraph 24. This is we talking about remand, my lord, 309. Paragraph 24. 23 kindly be seen, my lord, 23. 23. Keeping in view the aforesaid concept with regard to writ of habeas corpus, especially pertaining to an order passed by the learned magistrate at the time of production of the accused, it is necessary to adhere to the systematic postulate under the court relating to remand. There are two provisions in the code which provide for remand, that is section 167 and 309. Now kindly see 24. The act of directing remand of an accused is fundamentally a judicial function. The magistrate does not act in executive capacity while ordering the detention of an accused. While exercising the judicial act, it is obligatory on the part of the magistrate to satisfy himself whether the material placed before him justifies such a remand, or to put it differently, whether there exists reasonable grounds to commit the accused to custody and extend his remand. The purpose of remand as postulated under section 167 is that investigation cannot be completed within 24 hours. It enables the magistrate to see the remand is really necessary. This requires the investigation agency to send the case diary along with the remand report so the magistrate can appreciate the factual scenario and apply his mind whether there is a warrant for police remand or justification for judicial remand, or there is no need for any remand at all. It is obligatory on the part of magistrate to apply his mind and not to pass an order automatically or in a mechanical manner. So this is what I am saying. Why the remand? My lord, why this remand? Remand is that you have to periodically judicially he has to review. He has to apply his own mind every after 15 days, my. So I thought that I will place the judgment before lordship. And Madhu Lima, yes, 25, my lord, referring to Madhu Lima, 25, and Anupam, finding is this, my lord, last. Thus, the exercise of jurisdiction clearly shows magistrate performs a judicial act. So your lordship will just recall the order of 26/8/2022, my lord. So it is a judicial function. The magistrate has to deal it, my lord. This is what, because your lordship recall 26/8.
Paragraph 24.
Yes.
It says that this requires the investigating agency to send the case diary along with the remand report so that the magistrate can appreciate the factual scenario and apply his mind. So, is it dependent upon the investigating authority or the plea to remind the court that it is required for you to take a call on 436?
Yes, my lord, that is in respect of 167, that is. The investigation stage, my lord, one second. But now we are in trial.
Understood?
Yes.
Then would it be at the area of the PP out there to remind the court,
But-
that look here, the
but-
power of 436A is there, and as such, but we object to this.
But
granting of-
but my lord, the case record is before the learned trial court. The case record is before the learned trial court. My lord, accused is produced before the court. Once the period is over, every after 15 days he is produced before the court. The learned magistrate has to look into it. Now, while he looking into it, that 309, the subsection 2, my lord, then record has to be looked into it. It's not that, my lord, record has to be there.
Or is it your case that in view of Article 21, which is the basis for 436A, the magistrate has to keep a tab when a matter is before him to see as regards the requirement of, as to whether the requirement of 436A is met.
Right.
Or which means that there is an obligation on the magistrate
Yes.
to do it by himself if the period of one
Yes.
half of the period is over.
Correct, my lord, that is as per the section 3092, subsection 2. Is an obligatory on his part. Why this 436 has come into it? There is a reason behind, and there is a history, my lord. I don't want to trouble your lordship. In human also, my lord. That I don't want to trouble your lordship, right? It will be never ending. My lord, there is very old constitutional bench judgment. In 1953 Supreme Court 277, we have given that, my lord. 2-page judgment only. 1953 Supreme Court 277.
Now tell me, Mr. Dar,
Yeah.
what is the scope of objection that a PP would have?
Scope of
You have seen Satinder.
Yeah.
Then the PMLA judgment.
Yeah.
Wherein in PMLA, one aspect has been made very clear. That irrespective of the offense he has committed, because it has been mentioned more particularly in paragraph number 418, where the Solicitor General had stated that if you hold this particular concept of 436A to be such that in that case, there will be certain terrorists may go up. The Supreme Court said that no, we are not inclined to accept your submission to that.
Yeah.
Now, what is the scope of objection of the people? Then? Is the scope of the objection only limited to that the delay has been occasioned by the magistrate accused, or there is anything else?
Yes, that is the only caveat it's having. My lord, your lordship, recollect when I said the last my learned friend has read the judgment of the Supreme Court. That's the only caveat. The only caveat is, my lord, if it is, my lord, on the part of the accused, then it's a different thing altogether. So, lordship, I think my learned friend has said the delay is not occurred due to the part of the accused. Delays is due to the prosecution. Kindly see that last, I will read 2 paragraphs only, what it means by 2 paragraphs of the judgment of that. My lord, I'll just read this, then after I will take up that, my lord. Paragraph 4, my lord, kindly we see. Last part, no? Last part, my lord, para 4. My lord, my lord, paragraph 3, my lord, old act is parameter, section 344 is parameter to 309. At paragraph 3, last few lines, 3 lines. The trying magistrate obviously proceeding at this stage under section 344 of the criminal
Mr. Das, can we pick up this matter at 3?
Yes,
Let
no
me
problem.
finish up these matters with the other councils.
I have,
Pension is also another very important thing.
my lord, this matter.
Mr. Pukan, isn't it?
My lord,
Let me complete this matter. I don't have much matters now. I'll just finish up these matters and then I'll take it up at 3.
yes, no problem.
Because this court sits till 5. There's
No,
no
yes, no
problem.
problem, absolutely no problem.
Mr. Pukon, just think about it. What is the scope of it? Because that is a very vital aspect. If the scope of objection is further to that, because one thing this court can also be oblivious of, that yes, there might have been a delay at a particular point of time during investigation. There might have been at a copy. But as of now, the day-to-day trial is going on. So in that, both of you just think about what is the scope, whether the delay at that point of time would be there or the earlier delay, because what is being held in the 436A is a composite thing. The period is composite from investigation, inquiry, and trial. And even in one judgment, it has been said that the appeal period also would be taken in. Just think about it. Yes.
11. Item number 11.
Yes.
Yeah, please, Your Lordship.
Yes. So your thing is, he comes under the NPS. So she will be entitled to the GIS, leave salary, and gratuity.
Lordship. That has been given, Your Lord.
That has been paid. You've got that?
Yes, my lord. Terminal benefits are paid as per NPS method.
No, whatever may be, you have already got the GIS, leave salary, and gratuity. You have got it.
Right.
Area salary, it is in the process.
Yes.
And what else are you asking for?
My lord, I am paying for regular salary under pension, my lord, under Rule 1969, my lord. Since
How?
my lord, petitioner is appointed in the year 1994, my lord. Subsequently, her service was adjusted in the year 2000, my lord. Subsequently, in 2009, my lord, her service was again adjusted against the vacant post, my lord, but same is abolished already. That's
No.
why her.
First and foremost, tell me. You were appointed as a teacher?
Yes, ma'am.
How?
Our regular appointment, ma'am, that is the appointment order is at page 17, madam. May I read, ma'am?
So this appointment happened under what rule? 77?
77 rule, madam.
What is the order? What is the date of this order? 2394.
2394.
19,
Oh,
1994, madam.
oh. Your appointment was to a centrally sponsored scheme.
Yes, madam.
Then how do you get it?
Then, my lord, your lordship may again come to page 19, my lord. One post out of 82, my lord. Head of secondary allowed to contribute pay of 3,580. This second para your lordship found this post are created.
Then
Then her service was again adjusted at page 21, your lordship may found.
This was done in 2009.
2009 method against the abolished post method. That's why her salary stopped method. Subsequently,
Working as a Hindi teacher who was initially appointed in consolidated basic pay of rupees 12 so with effect as per DSP's order dated 12 is hereby adjusted against the vacant post of 12 the rules of subsequent.
and then one report is there at page 24, your lordship may found Usha Jyoti Gogoi at serial number 1, page 24, your lordship may found. Page 24, my lord, annexure 5.
Yes.
Srimati Usha Jyoti Gogoi was working as Hindi teacher who was initially appointed as Lengari Palika High School, Maithumi Pitapit, with a consolidated basic pay of 3,580. She was adjusted against the vacant post of Lengari High School, and Sri Vidhan Chandra Gogoi transferred by your office order number so and so dated 24/6/9 enclosed, but she was wrongly adjusted against the state post that there was no retired vacant post in the name of Podro Gogoi, and on that time Sri Podro Gogoi adjusted another post of the state school by comment letter number so and so dated so and so. In fact,
So you were excess, isn't it, Mr. This is the case of excess.
My lord, here page 21 of the writ petition will assume significance.
Yes.
Page 21, lordship, the petitioner has been exhausted. Down below, lordship will find this is issued in concurrence with Finance SIA Department approval. So this is the order of regularization.
that is not regulation, but it's a adjusted.
Maybe
some alteration or modification that is.
But she will be drawing regular salary on the strength of this letter.
No, my lord, that is against the abolished
No,
post,
not
that order.
regular salary, but the question is out there that if you see this particular paragraph at page 24,
Yes,
so number 1,
my lord.
you see, so and so was working as Hindi teacher who was initially appointed as so and so
My lord.
in the consolidated basic pay. Now,
Yes.
if you see that particular document,
Yes, my lord.
you will see that this was a centrally sponsored scheme, Hindi teacher.
Yes.
Okay, because the head of account was the centrally sponsored scheme.
Fantastic.
Fixed, and thereafter she was adjusted against the vacant post of so and so by so and so transferred by the office number so and so.
Yes.
But she was wrongly adjusted against the said post as there was no retired vacant post, meaning against a transferred post, she was adjusted.
Yes.
Now, the moment she is adjusted, the post will remain the same.
Yes.
So if the post remains the same, it cannot be an additional post, which is added, because that very person who was Bhadra Gogoi,
Yes.
that his post, he was transferred to some other place.
Yes.
And this particular person, in essence, it was not a vacant post.
Yes.
So it was not a question of adjustment at that point of time.
Yes.
The adjustment happened in 2009.
Yes, that's what my lord, page 21. I have just drawn my lord.
Adjustment taken by 2000 my lord, the year 2000 my lord.
That is what it is stated here in this paragraph. The adjustment couldn't have happened because there was no vacant post.
Yes, ma'am, exactly.
The adjustment therefore happens at 2009. That means in 2009, your appointment was regularized.
But in the year 2000, my lord, they have adjusted my service against the vacant post.
My lord, but that
2009.
Yeah, 2000
That-
my lord.
Huh?
2000 my lord.
No, that is the reason why it has been mentioned in this paragraph, which you have drawn my attention
Order is
to.
at page 19 my lord.
The
Your
page
lordship already
24.
read it.
Page 24, if you see
My lord,
the explanation. You see, and thereafter she was adjusted against the vacant post of so-and-so. By so-and-so transferred by the office memorandum dated, but she was wrongly adjusted against the said post as there was no retired vacant post in the same so and so. And on that time, Sri so and so adjusted another post of so and so. Iman. In fact, Bhadragoy was a Hindi teacher under CSS of that school, and he was transferred to other school on so and so, and hence the post was abolished from the school after he was transferred.
Yes.
So that when you was abolished, how could you have been adjusted to that post? So 2000 cannot be. So it has to be in 2009. That is why the approval is being given.
Yes, and
Although you do not strictly fall within that Monoharan committee, but otherwise you have come into service. Otherwise you were in a project or some scheme.
In the year 2000, my humble submission is that, my lord, from 2000, my lord, my service has been adjusted against the 82 norms of post, my lord.
Against?
Created by the finance department.
Against which post?
Against the post was created by the finance department, my lord. That is the ad hoc secondary allowed in the consolidated basic fare. There was at page 19, my lord.
Page 19, my lord, doesn't
Page
state of-
19 is the expenditure will be debitable from head of account so and so non-planned scheme. Secondary education assistance to non-government government teachers serving in non-government school salaries so and so. So it is in this head of account it is being there. But
And
you were adjusted against the post which was abolished.
in the year 2000, my lord, my post, I was adjusted, my lord.
Understood.
that
But
time I have
against
been
against
receiving, my
what?
lord.
You were adjusted against the post which was abolished.
2000, when I have been adjusted in the year 2009, my lord, that post has been abolished. But in the 2000 the order, my lord, that post is not abolished, my lord. That post is there, my lord. From there, I have been transferred to abolished post in the year 2009, my lord. Subsequently, by interference from your lord, this
Now in
honorable court, my lord,
2009, Mr. Counsel,
my lord,
you have accepted this order.
that was challenged, my lord.
This was order you have challenged it.
Yes, my lord.
Then
Then this honorable court have your lordship may kindly peruse the order is at page 25 minus 26 onwards, my lord.
without expressing any opinion on the merits of the case, the writ petition is disposed of to direct the director of so and so to consider and take a decision on the proposal made by the inspector of schools within a period of 2 months. This order was passed in 2015
Yes, my lord. Thereafter, my
from the
submission-
date of receipt of a certified copy. So the court did not decide anything.
Thereafter, they have adjusted my service, my lord, details page 29, my lord. Page 29 is the order, my lord, of director, my lord. In pursuance of government letter by number so and so dated 14/11/2017 and order of the Honorable High Court dated 23/11/2015 in WPC number 3496 of 2015 filed by Srimati Usha Gogoi and Amita Pal versus State of Assam. Other adjustment of service of the following two teachers are hereby made against the existing vacancy of the school as indicated in the scale of pay 14,000 to 49,000 so and so allowances admissible with immediate effect. That is the petitioner number 1, my lord. That's Usha Gogoi, my lord. Her
No,
post was-
understood. Here also, if you see the earlier one also, 2009, what has happened to this 2009? So you did not get your salary.
Yes,
As-
madam, from 2000, my lord.
there the
Due
thing
to
is-
abolition of post, my lord.
Anyways,
And
we will decide the bigger question later on.
my lord.
Let us first think that your area per salary out there is in proposed. You have already got your GIS, leave salary and gratuity.
My lord.
We'll take up the matter after. How much time?
We require some time, your lord.
No, for the area salary?
Your lordship, for the area salary, your lord. Because it is under process, your lordship.
stopped from 2011, my lord.
Now, have you left your claim for prior to that period from 2000 to 2009?
No, my lord. By that period, 2009 to 2011, I have been receiving, my lord. But subsequently, from 2011 onwards, my lord, my detention have been stopped and my salary also stopped. And due to interference by this honorable court, they have released my salary by passing the order of 2017, my lord. And I have also annexed the non-drawal certificate also, my lord.
Heard, Mr.
ILM.
ILM, the learned counsel appearing on behalf of the petitioner. Ms. D. Muthardi appears on behalf of the Secondary Education Department, and Mr. R. Borpujari, the learned standing counsel, appears on behalf of the Finance Department. Mr. appears on behalf of the Accountant General AE and no government advocate, and Mr. S.R. Bolua appears for the Director of Pension. It has been brought to the attention of this court by Ms. D. Mutahari that petitioner's entitlement for GIS, leave salary and gratuity have already been sanctioned. As regards the area salary for the period from 1/6/2011 to 13/11/2017, the proposal of the same have already been submitted by the communication dated 20/2/2023 to the higher authorities for further action. In that regard, a communication issued by the Inspector of Schools to the Director of Secondary Education dated 16/3/2023 has been placed on record, which is kept and has been placed during the course of hearing and is kept on record and marked with the letter X. As regards the question whether the petitioner would be entitled to the pension in terms with the Assam Service Pension Rules 1969, the same would be considered upon affidavits being filed by the respondent authorities, taking into account that it is the specific extent of the respondents that the petitioner comes within the ambit of the new pension scheme. List the matter when.
Okay, after 4 weeks.
List the matter on 3rd of May 2023. In the meantime, the respondents shall file their affidavits. Further to that, Ms. D. Musari, the learned counsel appearing on behalf of the Secondary Education Department, shall also apprise this court as to the status of the area salary of the petitioner for the period above mentioned.
17.
Yes, Mr. Khatonia.
On last occasion,
I was supposed to apprise the court lordship
For what?
regarding the status of the pension.
Yes, what is it?
They have said it is in process, lordship.
How much time?
They have not said it because I actually exact instruction I have not received whether they have submitted the proper proposal or not.
Okay, but this is 1 month before. You took 1 month because the last date was fixed on 17th to 2023. We are in 17th of March 2020.
Last date, the standing councillor apprised your lordship that
Let the matter
it
be
was
listed on
resubmitted.
17/3/2023, on which date the Director of Pensions shall intimate this court as regards the status of the petitioner's fund. So it is you.
that proposal has been received, lordship,
Then
because it was resubmitted. The second time they have submitted a proposal.
when did you retire?
But it's a 2014 lot.
This
31st January 2014 lot.
heard Mr.
It's the lot.
H. Talukdar, the learned counsel appearing on behalf of the petitioner. Mr. N.J. Khatunia appears on behalf of the Elementary Education Department, who submits that the pension proposal of the petitioner have been sent way back prior to 17/2/2023. Today, the matter has been fixed for the Director of Pension to apprise this court as regards the status of the petitioner's pension proposal. However, Mr. S.R. Borua, the learned counsel, appearing on behalf of the Director of Pensions, have failed to give any concrete, have failed to apprise this court as regards the present status of the petitioner's pension proposal. It is relevant to take note of that the petitioner had retired on
31st January 2014.
31st January 2014, and almost and 9 years have already passed by. Until date, the petitioner had not received his pension. Considering the above, this court fixes this matter again on 10th of April 2023, on which day Mr. S.R. Borua shall apprise this court as regards the present status of the pension of the petitioner. Full stop. Liberty is given to the petitioner to mention the matter for upgrading.
Obliged.
Mr. Borua, this is the second time.
Yes, yes.
The third time is we'll see the whoever the pension, the director's pension pays.
18.
Yes. What do you want?
My lord, I want reinstatement.
Huh?
Reinstatement in service.
Very good.
My lord, the petitioner was.
You have filed your affidavits.
Yes.
Affidavits, everything has been filed.
Yes, sir.
Why the matter has come up to today?
For final disposal matter.
Final disposal.
Yes, sir. Well, petitioner was suspended.
Oh,
And-
suspension.
Yes, rapidly covered.
Covered. So then he has intimated you.
Yes. That page 51, my lord, of that petition.
Page
51,
51.
51.
51. Then, Mr. Datta, what are you doing? You still want an order from the court? You should reinstate him
Yes,
if you are not in a.
For the instatement lawsuit, direct.
Okay.
Otherwise, lawsuit, in the recent judgment, division bench is honorable court has given observation. That's it.
For what?
For relevant paragraph. Para 70 lawsuit. For the reasons stated herein above, we hold that there is no merit in this appeal. However, since Rule 6(1)A of the Rule of 1964 permits the authorities to place an employee under suspension when a disciplinary proceeding against him is contemplated or is pending, and considering the fact that disciplinary authority has in the meantime been initiated against the person number 1 by serving a memorandum of charges upon him.
Yeah, that is okay.
Here, no more.
That aspect of the matter is already there. We don't even require the bill. If you see paragraph number 22 in Ajay Kumar Chaudhary, it categorically says that in the meantime, the words used by the Supreme Court is in the meantime, as the petitioner has been the petitioner have been granted given the memorandum of charge. Therefore, the benefit of paragraph 21 shall not be given, isn't it? Paragraph 22. Let us hear.
So far, may I read, madam?
Yes.
So far as the facts of the present case are concerned, the appellant has now been served with a charge sheet, and therefore these directions may not be relevant to him any longer.
See, that is why it is being given. And in this case, you have given the memorandum. In the case of your petitioner, have you given it?
No.
No, not.
Heard Mr. J. Patwari, the learned counsel, appearing on behalf of the petitioner, and Mr. S. Datta The learned counsel appearing on behalf of the respondent number 1, 2, and 3. The case of the petitioner herein is that the petitioner, that on the basis of an FIR filed by two persons, namely Sri Nara Bahadur Karki and Sri Dhruva Borua, before the Superintendent of Police, Vigilance and Anti-Corruption, alleging that the petitioner and one Muhammad Gulzar Hussain Lotmondal of the said revenue circle had jointly prepared a list of dalals and demanded rupees 8 lakhs from them. A case was registered, being ACB PS case number 9/2021 under section 7A of the Prevention of Corruption Act 1988. Pursuant thereto, on 2/10/2021, the petitioner was arrested and was forwarded to the court of the Chief Judicial Magistrate Kamrup on 4/10/2021 with a prayer to add section 13(2) of the Prevention of Corruption Act 1988. In view of the fact that the petitioner was arrested, the respondent number 3 issued a notification dated 11/10/2021, whereby, in exercise of the powers under section rule 6(2) of the Assam Service (Discipline and Appeal) rules 1964, the petitioner was placed under suspension with effect from the date of arrest, that is on 2/10/2021, until further orders. It further reveals from the records that the petitioner had moved a bail application before this court, which was registered and numbered as BA number 2813/2021. And this court, by an order dated 18/11/2021, granted bail to the petitioner. Thereupon, the petitioner on 11/1/2022 informed the respondent number 3 that he had been already released on bail and requested that he be reinstated to service so that he can resume his duty. It is the case of the petitioner that till date, the respondent authorities have not initiated the departmental proceedings. Even though a period of almost 1.5 years have expired. It is the case of the petitioners that the petitioner have also not yet been served the memorandum of charge charge sheet. And taking into account the judgment of the Supreme Court in the case of Ajay Kumar Chaudhary versus Union of India versus Ajay Kumar Chaudhary, reported in 2015,
7 SCC 291.
7 SCC 291, the currency of the suspension period could not have gone beyond the period of 3 months without serving the copy of the memorandum of charge the charge sheet upon the petitioner. Mr. I've also perused the affidavit in opposition as well as the affidavit in reply. Affidavit in opposition filed by the respondents as well as the affidavit in reply. Mr. S. Dotto, the learned counsel appearing on behalf of the respondent, duly submits, fairly submits that as on date, the memorandum of charge oblique the charge sheet have not been served upon the petitioner. The learned counsel appearing on behalf of the petitioner, Mr. J. Patwari, has drawn the attention of this court to paragraph number 21 of the judgment in the case of Ajay Kumar Chaudhary. Supra. Which categorically mandates that the currency of a suspension order should not extend beyond 3 months if within the said period the memorandum of charge oblique the charge sheet has not been served on the delinquent officer employee. The learned counsel has also referred to the judgment of the Supreme Court in the division bench of this court in Rekibuddin Ahmed versus State of Assam and others reported in
2019 GLP.
No, it is there. You have a Rafid Ali judgment.
Yes.
It is the citation is there.
Yes. So, my lord, I have got the.
Rekibuddin?
No, it is there. Huh?
Rekibuddin?
Huh?
My lord,
2020
2019
2GLR.
2000?
2020
Uh,
2GLR 621.
621. And submitted that the division bench of this court had categorically held that the law laid down in Ajay Kumar Chaudhary Supra duly applies also to deemed suspension made under Rule 6.2 of the Assam Services Discipline and Appeal Rules 1964. This court, taking into account the state submission and after hearing the learned counsel, finds it relevant to quote paragraph number 21 of the state judgment or of the judgment in the case of Ajay Kumar Chaudhary, which is reproduced here in under. Admittedly, in the instant case, as the memorandum of charge oblique the charge sheet have not been served upon the petitioner, and the period of 90 days have already expired. As could be seen from the date of intimation. To the appointing authority, which was on 11/1/2022, na?
Yes.
22.
Yes.
This court is of the opinion that the further continuation of the suspension of the petitioner would be in violation to the order, violation to the judgment of the Supreme Court in the case of Ajay Kumar Chaudhary Supra. Accordingly, this court therefore directs the respondent number 3 to forthwith reinstate to the petitioner on the basis of a certified copy of the order being served upon him. Before concluding, this court further would like to take note of, further would like to observe that the government, the responding authorities would be at liberty to transfer the petition to any of its offices within the state, so as to sever any local or personal contact that the petitioner may have and which he may misuse for obstructing the investigation against him. The respondent authorities are further given the liberty to prohibit the petitioner from contacting any person or handling records and documents till the stage of the petitioner having to prepare his defense. With the above, the instant petition stands disposed.
My lord, the suspension order dated 11/10/21 needs to be satisfied.
No. Mr. Patwari, you know the consequence why I did not do it. The moment I do it, you'll be treated as duty. Isn't it so? Then,
And my lord, they have not also paid my subsistence allowance during this period. My lord.
you have asked for subsistence allowance?
Yes, my lord. My lord, yes, my lord. Subsistence allowance, and my lord, if I don't ask also under.
Have you asked for in the petition?
Yes, I think so.
No, Lord.
Then, attend.
No.
You want? We are ready to receive another petition.
Deeply obliged.
Now, Mr. Doctor, what do you say? The moment I set aside,
Yes, Lord. Yes.
because the Supreme Court does not say
To set aside.
to set aside. It says further continuation with that after 3 months.
Yes.
Because the moment I set aside, it has to be
Yes.
treated as period on duty.
Right. Obliged.
19.
May I please repeat?
Yes.
But in this matter, Lordship, earlier, the occasion also updated, Lordship, but there's some instruction, Lordship. But in this matter, what happened, Lordship?
Has
I
drawn
was
the
appointed
attention
in
of this
2000
court to Iman, which is the appointment order. The petitioner, however, on the ground of approval of the dated Iman have expired on Iman. It's not by prospective. Who? This was expired. The learning council on behalf has drawn the attention of the director has informed the the approval. Yes, what do you have?
Yes, ma'am. He was not appointed under compassionate ground, my lord. This is the word specific stand.
Huh?
He is not appointed under compassionate ground, my lord.
You were not appointed against compassionate ground?
Yes, my lord. My lord, kindly see the serial number 2 and page 4 of the branch, my lord.
Page
Page
4
4.
of the branch.
This is the letter dated, my lord, 4/2/2019.
I have the honor to state that to end so. Who is he?
He is the petitioner, my lord.
Abdul Alim Khan, ex-governor of the Madras. But sir, in his service period, he had surrendered. He was martyred by extremists, and from that time, I was working as a portrait employee against my father's now. But sir, my service is not regular due to negligence to the Deputy Commissioner. Yes, what do you want to show from here?
This is the application made by him to appoint on compassionate ground. He addressed to the Commissioner to Government of Assam Education Department, my lord. Subsequently, my lord, his application was forwarded to the Deputy Commissioner Dhuri and Inspector of School, letter serial number 5, my lord, 11 July 2019. Page 5.
Praying for compassionate regularization of appointment on the strength of police report indicating was designated by the enclosure and court of right to Oh,
And his order of appointment is, my lord, in the writ petition, it is in the year 2013, my lord. And now he is claiming that this is the order on compassionate appointment, my lord.
let us not go into that. But the thing is, the reason why he has not been given is because the approval of the finance department had expired. Isn't it so?
This is the, my lord, this is the
And it has been sent for post facto approval somewhere, if I remember.
page 30, my lord. Page 30 of the writ petition, my lord.
The government is therefore requested to accord post facto. So let us not go into that compassionate thing and all. We are not concerned to that effect. But he was appointed against a particular thing. He was appointed, but there later on it has not been regularized because of the fact that from 2008 onwards, that SIO approval had expired. This is the status of the director of madrasa.
Yes. So, my lord, may I pray one thing, my lord? Since there is some dispute regarding his appointment, it's better to file a detailed affidavit.
No, you file. I'm not asking you. Finance.
There is no dispute in the appointment.
You see, the problem which has happened is this. With reference, I have the honor to inform you that the Iman so was killed by unknown miscreants on Iman in compliance with the orders dated Iman and as per resolution of the managing committee. The post had the approval of finance and the validity of the FI expired on 31/7. In this connection, it may be stated that the appointment was made without the approval of the government at that point of time. Government is therefore requested to accord post facto approval to observe.
No, finance has given approval.
But that has expired.
No, yes, approval with regard to the post, not with regard to the person who is manning the post.
No.
Yes. Now, before that, this is a fallout, my lord, of the Honorable High Court's order at page 25. Page 25 of the writ petition. Petitioner, my lord, I'm reading from the second paragraph. Petitioner is before this court seeking an appropriate direction to the respondents to consider his case for compassionate appointment following death of his father in harness on so-and-so. It is submitted at the bar that the issue is covered by judgment and order dated so-and-so passed in batch of writ petition so-and-so. That means, my lord, with regard to compassionate appointment, having regard to the issue raised and the decision of this court as above, this petition is closed with a direction that the petitioner's case would be now considered in terms of the guidelines laid there.
So you are saying that the petitioner got an order from this court for a compassionate appointment, but he was already appointed.
Yes.
In fact, his case was for compassionate regularization. No, I'm not saying.
It is, yes, yes.
No, why I'm saying is this. You
My
kindly look at this document. See, page 5. The third line. Page 5, third line.
Yes. With regards to the subject cited above, I am directed to enclose here with a prior petition dated 4/2/2019, submitted by so-and-so praying for compassionate regularization of appointment on the strength of police report indicating that his father was assassinated by motorcycle-borne assailant. The enclosures and copy of Honorable High Court Order and Judicial Department's advice to
Mr. A.U. Ahmed, the learned counsel for the petitioner.
May I show one more thing?
Yes.
Kindly see the page.
No, let them file an affidavit.
Okay, what happened?
You see, the question of post facto approval and all these things will have a question as regards the affidavit. We'll have an affidavit of it.
But Latif, I have an interim prayer Latif from 2013 Latif, not a single month I get the salary Latif. At least pending salary, maybe arrears salary may be released Latif.
We'll see on the next date. Mr.
Our
Spencer,
family
the
not
learned
complete
counsel appearing on behalf of the petitioner, and Mr. N.J. Khatonia, the learned standing counsel appearing on behalf of the Secondary Education Department, and Mr. R. Puzari appears for the Finance Department. Mr. N.J. Khatami, the learned counsel, submits that as per his instructions. The petitioner was already appointed temporarily at the time when his father had expired. Thereupon, the petitioner when did your father die?
2006, Lord.
Huh?
2006. But you kindly page number 20 is the police report, Lord. I have an expert. Killed by some extremist, Lord, miscreant, Lord. Therefore, he was appointed, Lord. Initially, he was voluntarily serving from 2006 also, Lord. Kindly see appointment letter of the principal, Lord. Page number 22.
20?
22. His appointment, Lordship. He was appointed in 2008 with effect from 2006, Lordship. This is my initial appointment, Lordship.
And then?
Thereafter, Lordship, from as per court order, I was appointed by the Director of Mother's Education in 2013, Lordship. Here is mentioned the court order also. As per court order. This is not my fault in my part, Lordship, how they appoint me.
Yes, Mr. Borbuzeri.
Yes, page 19.
Huh.
Page 19 of the writ petition goes to show, my lord, that the father of the writ petitioner expired on 19/3/2006. When, and my lord, FIR was, my lord, registered. Thereafter, my lord, on date of his father, on honorary basis, my lord, this Madrasa appointed him. Just it is an appointment, my lord, not by the government. Thereafter, he realizes, my lord, on the death of his father, he could have laid, my lord, a claim for compassionate appointment. He approached this honorable court, and this honorable court, my lord, have passed this order, saying that, my lord, his case appears to be covered under, my lord, the scheme of compassionate appointment. Now, thereafter, my lord, the procedure laid down in, my lord, Ranjan Das as well as Pajaron Nessa, if that is to be applied, then his case has to be, my lord, placed before the DLC. Then, my lord, on recommendation of the DLC, it will have to be placed before the SLC. But their instructions, my lord, which, my lord, my learned colleague has just now placed, if Lordship is pleased to peruse this bunch of papers.
I've seen it.
Yes, they are Lordship will see, my lord. Kindly see, my lord, that paragraph.
So did you consider the DLC and SLC and all?
No, not considered. That's what.
So without following Asut Ranjan, he has been given this.
Yes. So therefore,
They
my
can
lord,
appoint without following this, because my father killed by extremists, Lordship. There is some provision also, government provision also. There. They can without follow any provision, they can appoint me, Lord. And director called for record. Director instructed me to submit all record.
No,
We have
understood.
submitted.
No, Mr. Counsel, I understand very well. In fact, what has been done in your case
Yes, Lord.
should normally be done for compassionate appointment. On the day when your father had expired, on the next day you have been given. Very well. I think this is the proper thing which needs to be done. And in fact, the recent Supreme Court judgment also said that within 6 months you are to be given the appointment or to decide it. This is done. But what do you do as regards Asut Ranjan Das judgment, wherein it says that it has to be done by the SLC?
But
DLC and SLC?
Lordship, how can?
Because here, the judgment which you are relying upon,
Yes, Lord.
the order also said at bar that the issue is covered by the judgment of so and so. So your thing is, your consideration has to be in terms with this judgment.
But Lordship, but question is, Lordship, I am appointed in 2013, Lordship. Whether they appointed following the procedure or not, Lordship, I am not responsible for that, Lordship. I am the petitioner. I have applied, Lordship. Now they raising this question after 9 years, Lordship. I am continuously serving.
Did you get your salary?
No, not a single day, Lordship.
That is why you are not getting the salary. Because here the director of, what do you call, which
The
school?
fault of director.
Madrasa Education.
Page 26.
Yes, Madrasa Education thought himself that he is the owner of the entire
Yes,
schools.
this is
How does
absolutely
he
wrong
do it?
interpretation of this
Tell me.
decision.
How can this be done? So and so ki likh le? Mr. Ajay Kumar had submitted some instructions to the effect that the petitioner is not at all entitled for the claim as made for in view of the petitioner's appointment is illegal. Taking into account his submission, this court deems it proper that the said be put on record by way of an affidavit so that the petitioner is in a position to rebut to such allegations. So 3 weeks' time is granted for filing the affidavit. This is the matter again on 8th of May 2020. Well, this is what has happened is wrong.
No, this is without jurisdiction, my lord. He has given his own interpretation, my lord. I am obliged.
Continue. 20. Yes. Yes, what is the status?
Yes, my lord. So there was a confusion, my lord, in the department whether GST is applicable in this amount or not. And thereafter, the finance officer, my lord, came up with another query whether income tax can be deducted, my lord. Well, that confusion has been cleared, my lord. That as because the petitioner, my lord, he is an ST. So, my lord, as
1026.
1026.
Then
That has been, I've communicated them all these things, my lord. So,
7 days. Earlier it was 10 days.
Yes,
Now
sir.
it is 7 days.
Yes,
Disburse the amount. Heard, Mr.
as Bora.
As Bora, the learned counsel appearing on behalf of the petitioner, and Mr.
PK Munir.
PK Muni appears on behalf of
3 and 4.
the respondent number 3 and 4. The learned counsel for the respondent number 3 and 4 submits that there were certain confusion for which the payment to which the petitioner is entitled to could not be made. But however, the same had already been clarified, for which the said respondent number 3 and 4 shall disburse the said amount of rupees 22,29,558 to the petitioner within a period of 7 days. Taking into account the said submission, this court therefore disposes of this writ petition with a direction to the respondent number 3 and 4 to disburse the amount of rupees 22,29,558 within by 12th of April 2023 without pay.
My lord will record my name. 1 and 2, my lord.
Mr. Ardhar Upor Likhi appears for a response number 1. So I have given you more time than that.
My lord, but I'm
Almost 1 month,
obliged.
but you have to pay
My lord.
without pay.
21.
Yes, elementary.
Yes, ma'am, I have received some instruction, my lord, regarding pensionary benefit. the petitioner is the second wife, my lord, and earlier she was paid the leave salary, GIS, specialty, etc. Subsequently, first wife made a complaint, my lord. Then after that, regarding the final pension, my lord, it was stopped.
Yes. Now, what do you propose? Is the other person a party?
Other person?
No. Because here there is a conflicting claim. The petitioner is the second wife.
Yes, my lord. It's admitted fact, my lord.
It is admitted. Then why the first wife has not been made a party? Where is it mentioned that there is the second wife?
Good question. Second wife, question. Paragraph 4, no? Page 5, my lord. Page 5, third line. Hereafter, on inquiry, petitioner came to know that earlier wife property.
Nothing has been given. The petition should be dismissed on that count itself.
And thereafter, he married the petitioner, my lord.
And this is Hindu or an ST?
ST. ST.
ST, then 366.25 will apply. And as such, I don't think that second marriage would have any impact.
Yes.
They may have a right.
More than case of
Can you file a short affidavit on this point?
yes, ma'am.
Mr. Ajay Kumar, the learned counsel appearing on behalf of the petitioner, on behalf of the respondent, submits that in view of the fact that the first wife of the husband of the petitioner, the first wife of late Ilesor Isolary have claimed the release of the pension in her name. The final family pension proposal of late Ilesor Isolary is yet to be completed. The petitioner today is not represented. The instructions were placed by Mr. Ajay Kumar is kept on record and marked with the letter X. Taking into account that the fact that the petitioner is not represented, let the matter be again listed on 10th of April 2023, on which date the learned counsel for the Director of Elementary Education as well as Mr. Pension Accountant General. You are the Director of Pension?
Director of Pension.
As well as Mr. S.R. Borwa, the appearing on behalf of the Director of Pension, shall apprise this court as regards the present status of the family pension of late Ilesor Isolary.
26.
Yes.
My lord, the petitioner already got clarified.
Lordship, earlier, item 26 instruction is dated, Lordship.
375/2023. Is your matter filed before you 375/2023? Mr. S.R. Rabha was appearing on
Yes,
the
Lordship,
earlier
that is
occasion.
why he is not available today, Lordship. He trusted me to take time, Lordship. If he is not with me, Lordship.
Okay. Matter was pertaining to what? The long order.
The matter is
LDA.
non-payment of salary of 1 month, Lordship.
Salary of 1 month.
It was transferred from Tamulpur to Kokrajhar and Kokrajhar to Tamulpur.
Cultural.
Oh, that
department.
one.
Cultural department.
I remember. Cultural department.
Next I shall cooperate.
List the matter again on
My lord. May I please?
27th of March 2023, on which date the learned counsel appearing on behalf of Dimazo,
BTC, Lord.
BTC, shall apprise the court as regards the instructions sought for in terms with the order dated 27/1/2023.
27.
Meet fees of workshop, the
Hmm.
matter pertains to payment for.
Yes,
pension.
irrigation department,
Yes, my
as to
lord.
whether the post of junior engineer can be filled up by a person who is under matriculate.
My lord, as per notification, my lord, the petitioner should be, my lord, for the post of junior engineer should be matriculate and have ITI pass and have 15 years of experience, my lord.
And does the petitioner
He
have
is
it?
not past matric pass.
I do not have, I am not matriculate, my lord. So I was promoted, but be that as it may, my lord, I'm entitled to pension in whatever capacity, but the promotion order was passed just
No,
2
my
months
lord.
prior to my retirement, my lord.
My lord, he has submitted a metric certificate, SSLC pass certificate, which has been verified by the department, and as per SEBA's verification, he has not passed metric, my lord.
He is not passed
No, my
metric.
lord, he has submitted a metric pass certificate, my lord. That by the time when the pension paper is made ready, my lord, this fact is come to light.
But madam, is he not entitled to pension?
As he is not metric pass, my lord, he has submitted for documents, my lord. In the for documents, he has
He had
promoted to junior.
submitted false document
Yes,
at the
my
time
lord.
of his appointment.
Yes, my lord.
My lord, I had applied in the RTI.
My lord,
Madam,
this
I
is a-
think the
this is
better
a-
of you should put this on affidavit so that he can rebut it. Miss D.S. Neob, the learned counsel appearing on behalf of the respondent number 1, 2, 5, 6, 7, and 8 submits that the petitioner at the time of seeking appointment have submitted certain false documents. Taking into account the said, this court deems it proper that the same should be placed by way of an affidavit so that the petitioner is in a position to rebut to such allegations. List the matter on 8th of May 2022.
deeply of-
Deeply of
28.
Yes.
My lord, in this case, my lord, some instruction was awaited. my lord.
Yes,
Can you
have you
see-
got it? You wanted something, no? He has
Can you
joined.
see, my lord, order dated 6/2/23.
Huh?
6/2/23, my lord, kindly see order dated 6/2.
6/2 today appears on record the petitioner herein was appointed as the assistant teacher and posted as to the husband of the had initially filed an application before the special under the state application.
Any second.
Fine.
9.
If yes,
Yes, well, I have received an instruction. Well, I have placed
Ah.
an instruction. She was absent since 31/8/2006, my lord.
now tell me one thing. He asked, as per his information, certain documents.
Yes, my lord.
Okay. Now, what is this document which he is asked for? That is one related paper, self-signed and enclosed. So what is the document he has asked?
For furnishing the copy of application for granting leave.
Application?
Order, my lord, order of my lord, order passed by
Where is that? Where is the document which you
Yes,
have
my lord.
sought for?
page 26, my lord, kindly see.
Page
26.
26. Okay. Before we the leave submitted by Sri Anjan Bharali before the Education Department on behalf of his wife so and so. Order passed by the secretary. Now, whether any order was passed or any application was filed?
Thereafter this order, my lord, page 28.
Huh?
Page 28, kindly see, my lord. Order was passed on 18/6/22.
With reference, I'm quoting here. Okay, then. No, but you are asking for two documents.
Yes.
The first of the document is pertaining to the leave application filed by your husband against you,
Yes.
Sarudas. And the second is the leave being granted by the authority concerned. Okay. Regarding RTI, Sarudas, so and so. Now, what instructions you have got?
Well, second page of the on. So
Ah.
this is the letter written by the principal of the school, my lord.
Second page.
Second
Yes.
page 2, my lord.
Ah. Like
Fifth line, my lord. Her last attendance in the school was on 30/8/2006, and she has been absent from the school since 31/8/2006 till date without any information to the school. No leave application from her has been found in the office school. No order from any higher authority granting her any kind of leave has also been found in the office of the school.
But my lord, kindly see my lord page 18, my lord. 18, kindly see.
Yes.
My lord, this is the application submitted by the husband of the petitioner.
Sir, it is impossible on his part alone to maintain my family. For it. Sir, here I would like to state that honor to kindly instruct that he have taken for crafting people medical year with effect from 28/3/2002. Huh?
No, my lord.
With effect
28/3,
from
2009, my lord.
Huh?
28/3/2009.
What is the date of this document?
My lord, 3/3/13, my lord.
Where is it?
My lord, it is not clear here, my lord.
Then
As per instruction, my lord, it was submitted. My lord, thereafter kindly see my lord page 19. This was my lord medical leave in respect
including
of
here
discharge.
is a copy of the letter received by Non-drawal so and so, the content of which is explained.
Yes.
We request you to kindly put into the report. What is the date of this?
Let me, my lord, 7/1.
Yes.
7/1/22, my lord.
What?
7/3/13, my lord. That's 7/3.
Where's the
March
date?
13, my lord.
Where's the date? 13, where are you getting?
Well, from the instruction.
What?
From the or instruction it was made. It was given, my lord. But clear copy is not here, my lord. But ultimately, my lord, leave, a medical leave was, my lord, that petition was filed, my lord. It is clear from this order.
But there is nothing out there. I don't know whether that document has been filed. That document is not authenticated. There is no receipt from anybody. You are enclosing a particular document which is absolutely illegible. There is no date mentioned about this document. And if you are doing it in the year 2009, in respect to a period, seeking leave for which period?
28/3/2009. My lord, kindly see, my lord, one medical certificate is also there, my lord. Page 17, my lord.
Yes.
Page 17, kindly see.
This is of 2013.
Yes, my lord. But
And you have sought for medical leave when?
Since 2009 to 2013, my lord.
Huh?
2009 to 2013, my lord.
You, in 2009, you were seeking a medical
My lord, he was suffering from-
leave. You are submitting a leave on the basis of a medical certificate which has come into existence in 2013.
My lord, she was suffering from mental problem, my lord, mental. So, my lord, she could not submit the document. And on her behalf, my lord, the husband of the petitioner submitted this document, my lord.
Now, tell me, if this is the document,
Yes.
kindly see the penultimate paragraph at page 18. That, sir, she is in a position to resume her duties subject to granting leave on medical grounds from the same period. Which period? So, I, on behalf of my wife, request your honor to kindly instruct the DSC for taking necessary for granting a leave on medical grounds for a period of 3 years with effect from 28/3/2009. What is the date of this document?
And as per instruction, it was 3/3/13.
Can be 3/3/2013. If you are you asking this on 3/3/2013 for granting it the leave from 2009?
My lord, since 2009 to my lord 2013, she was my lord suffering from my lord mental problem. Therefore, my lord, her husband my lord submitted this document before the authority.
Mr. Counsel, let me tell you one thing. If this court dismisses this petition on the strength of this, that there is no document, all your things finishes.
Yes.
You have filed an appeal before the year. That appeal will also go.
Yes.
What do you want to do? Here, as per the instruction of 13/2/2023, there is no leave application or any order of the higher authority granting leave to your wife. Okay? Or who has filed this? You.
Yes.
There's nothing else. So under such circumstances, this court would have no other option but to dismiss it if those two documents does not arise on the basis of this document. So better off, as you are still prosecuting the leave application there, why don't you take up the stand out there something? This court can very well dismiss it on this ground. But would you like to do that? And thereby foreclose whatever appeal you have filed, everything finished off?
Yes.
Because that is a authority by which they can keep on calling, see the records, ask for all these things. For this court, it is because there is already a second appeal filed.
Yes.
So I think you better pursue with the second appeal before
Yes.
it.
Yes.
I won't record this thing instruction, because heard Mr.
R.S. Chauhan.
R.H. Chauhan, the learned counsel appearing on behalf of the petitioner, and Mr. N.J. Khatonia appears on behalf of the
Secondary Education Department.
Secondary Education Department. The learned counsel appearing on behalf of the petitioner on instruction submits that as there is already a second appeal which have been filed and presently pending before
For my lord, Chief Information Commissioner, Sub-State Information Commissioner, page 29.
page 29, before the Chief Information Commissioner, Assam State Information Commission, he would not like to press the instant writ petition. Rather, he would, the petitioner would take appropriate steps through her husband before the said proceeding, or individually separate to the said proceeding, taking into account the instant petitions stands dismissed on withdrawal. Full stop. The withdrawal of the instant petition shall not affect the rights of the petitioner to pursue the appeal so filed by the husband of the petitioner before the authority concerned.
Obliged, Lord.
Obliged.
Yes, you got something? Like to include your with.
But here I'm praying for some time, Mother.
So you are taking steps with the deputy commissioner, with the deputy inspector of school.
Yes, madam. So I'm praying for some more time, madam.
Mr. N.J. Khatonia, the learned counsel appearing on behalf of the petitioner, on behalf of the, which department? Elementary Education Department. Seeks for an accommodation of 3 weeks in view of the fact that the Director of Elementary Education is presently pursuing the matter with the Deputy Inspector of Schools as regards the entitlement of the petitioner. List the matter again on 10th of April 2023. Also, liberty is given to the petitioner to mention the matter for upgrading. On the returnable date, the learned counsel appearing on behalf of the Elementary Education Department shall apprise the court as regards the instructions sought for in the order dated 27/2/2023.
31.
You become useful, then we'll see. Yes, Mr. Gupta.
Petitioner has already returned from service.
petitioners claim for financial benefit that petitioner has not been promoted from 2013 and they were given from 2016. Petitioner was supposed to be promoted to the post of sub-inspector of statistics in 2013 as junior to the petitioner has been promoted. After that, the petitioner has approached this court and this court directed to consider his representation. Thereafter, Lordship, petitioner has been given promotion 2016. Thereafter, Lordship, the authority has been timely again said that petitioner should be given retroactive promotion with financial benefit. That has not been considered. The director has wrote a letter to the finance department at page 76, Lordship.
Understood. Mr. Bora, what instructions you have?
Your Lordship, I have received instructions from the Directorate of Economics and Statistics, but the instruction from the Department of Transformation and Development is awaited. So I just take 1 week time. They say that I just had a telephonic conversation because the Directorate has forwarded the representations to the department. So they
We'll have it on, what do you call, 3rd of April.
3rd of April.
Get your
By
instruction.
the time I'll file the affidavit also.
Mr. S.K. Goswami, the learned counsel appearing on behalf of the petitioner, and Mr. D. Bora, the learned standing counsel appearing on behalf of the respondent number 1 and 2. Mr. A. Hassan
For respond number
for
4.
the respondent number 4, and Mr. Arbor Pujari appearing on behalf of the respondent number 3. 3 is finance, no? Also, Mr. D. Bora, the learned counsel submits that he requires an accommodation for a week so that he can obtain the instructions in terms with the order dated 22/2023 and file an affidavit in the meantime. Then the matter be listed again on 3rd of April 2023. In the meantime, the respondents number 1 and 2 shall file the affidavit. 32. Yes.
Here, please, Your Lordship. Lordship, on the last date, instructions is sought for with regard to the orders passed by the honorable court in writ petition and a contempt petition. Lordship. Matter retains pertains to finalization of petition.
So there is some development.
Page 9 and 10 of this bunch, madam.
Of what?
I have ordered the bunch of document, madam. Page 9 and 10.
You are asking for time scale pay.
Time scale promotion.
Time scale promotion. Deducted amount of 50 and 25% at the time of suspension with effect from so and so to so and so along with increment. Now this is proposals have been submitted.
For 50% and 25%, madam.
Yes, it has
And
been
if any
done.
ACPS
Now, as
proposal,
regards GIS amount has been sanctioned. You
Yes,
got
sir.
it. GIS
Lordship,
provisional pension have been sanctioned.
Lordship, provisional pension I have already received.
Okay, provisional DCRG you have got it.
Lordship. The final
Leave
DCR
encashment money have been sanctioned. You have got it. Leave encashment money has been sanctioned. 16.5. So these two proposals are presently going on.
Lordship.
How much time? Oh, when are you going to give the final DCRG?
in fact, this proposal has been sent to the finance department, pension department, madam, way back in the year 2020, madam,
To the
to the director of pension, madam.
yes, pension, Mr. Borua.
32.
Why the DCRG, final DCRG has not been given? There is nothing out there. There is neither any judicial or departmental proceedings against him. Then why this amount has not been paid?
Second.
Okay, we are not made a party here.
Yeah, the problem arises, madam.
Pension is not. My thought was.
See?
But you will serve a copy, but you- the party will serve a copy.
Heard Miss A. Talukdar, the learned counsel, appearing on behalf of the petitioner. Mr. N.J. Khatuni appears on behalf of the respondent number 1, 3, and 4. Finance not available. None appears on behalf of the finance on call. Mr. N.J. Khatunia has submitted that the proposals for the pension as well as, Mr. R. Pujari appears for the finance. Mr. N.J. Khatunia submits that the proposal for the finalization of the pension and the payment of the DCRG, final DCRG, is pending before the Director of Finance. Pension. He therefore submits that the Director of Finance is required to be made a party in the instant proceeding. Taking into account that the matter pertains to pension and pensionary benefits, this court, in the interest of justice, impledes the respondent number, the Director of Pension having their office at Moidamgao,
No,
Houseway Complex.
Houseway Complex, 186.
Guwahati 781006 as the respondent number 5 to the instant proceedings. The registry shall make the necessary correction of the records. Mr. S.R. Borua, the learned counsel, being present in the court, have accepted notice on behalf of the newly impleaded respondent number 5. Ms. A. Talukdar shall serve extra copies of the writ petition during the course of the day. Full stop. Let this matter again be listed again on 10th of April 2023, on which date the Director of Pension shall that's the respondent number 5, newly pleaded respondent number 5, shall apprise this court as to what is the status of the final DCRG as well as the pension of the petitioner. Liberty is given to the petitioner for mentioning the matter for upgrading. Mr. N.J. Khatunia, during the course of the hearing, had submitted a bunch of documents which is kept on record and marked with the letter X.
GA Assam name may be shown in the court list.
The registry shall also indicate the name of Mr. S.R. Burwa as a learned counsel for the respondent.
33.
Yes. Oh, Mr. P. In one matter I have disposed of or something, some orders I have passed, you were not there. But nothing adversarial to you. I've asked them, you had a matter in orders, no?
My lord, in that case, I am already returned to brief.
Okay, but then also this court passed
I'm very
favorable orders without you.
I'm obliged.
Lordship, we have the instructions. The
Memorandum of charge?
Memorandum of charge has not been framed.
So, you have intimated, you are done under 61C. No memorandum of charge. No disciplinary proceedings initiated.
But he have informed us on 8/2/23, Lordship.
3 months is there.
Stating that I have been released on 30/11.
Huh?
Stating that I have been released.
Why did you?
Well, since
inform
I am
after 3
visiting
months?
the office, my lord. They
Huh?
know I am visiting the office, my lord.
Understood, but you were suspended by the appointing authority. Are you visiting the office of the
Yes, my
appointing
lord.
authority?
That is my office. That is my office. Superintending. wherein I am working,
Who is your appointing authority?
superintending.
And who are you? What is your post?
I am a senior assistant.
But you have to intimate him.
I'm visiting the office, my
So what?
and in the
That
representation,
person may not have the knowledge about that you are doing it.
in the representation, I have stated, my
But why didn't you intimate?
since I am visiting the office, my there is no more letter to that.
Because this, if we open up that, no, that will open up another Pandora's box.
Well, since
Visiting the
I have
office.
stated in my representation that I was.
Then why, if you were visiting the office, why you did not intimate them? Tell me that you have got a bail order.
I have submitted the order before the
No,
order.
no, why? Why?
There is no written order.
Then
That is admitted. Since I am visiting.
I can't help you. No, not written. You were only to submit one document. That look here, I've got the bail. That's all.
I have submitted the bail order. My
Where? Where's the receipt?
receipt is not there.
Then when did you submit?
On 1/12.
Where is it?
I have submitted it for the authority.
Yeah.
There
I
is no
can't
receipt
help
there.
you there. Just take care.
But the representation says, well, I have been released on 30. There are 4 paragraphs. Page 40, paragraph 4.
8/2/2000. Then why? Tell me, why did you give on 8/2/2023?
It's an appeal, my lord.
Appeal to whom?
Appeal to the
Appointing authority. Appeal does not arise to the appointing authority because he is the authority.
Since the petitioner is not aware of the my lord.
Then I'll help you out there. Hello. Do one thing. We follow as per Rafed Ali. Give them the opportunity that they may reinstate you in between that.
Yes.
Otherwise, they have to reinstate you by me. That is the only way. Well, we'll dispose it of. Yeah. In the meantime, if you give the memorandum of charge, matter goes. You have still time till May. 8/2. 7/3, 7/5. You can give. Then it is okay. But if you don't give it, then you have to reinstate it. That is the order, which is there exactly in Rafed Ali.
Yes, sir.
Dispose it of in your presence.
All right.
I'll come back in 5 minutes. Mr. Das, I'm going to take up your matter. Don't worry. But I'm just about to finish up these there also.
Lordship,
Who was appearing in the matter against you? Who was the other counsel who was appearing?
I was able.
Shishon.
In this case, Lordship, they have submitted it on 3/12, Lordship. 3/12/22. 3/12.
So you no memorandum of that. So this will also, you have to reinstate. Get the order. Huh? Do this book.
43.
Yes,
My
you
Lordship.
got something?
Yes, Lordship. Lordship, I'll just pass on the instructions, Lordship.
Hmm.
Lordship, here the main hurdle which the Treasury officer is facing, Lordship, is that the headmaster, the DDO, needs to issue the non-drawal certificate or drawal certificate, my Lordship. Lordship, I'm just.
Who is appearing for the headmaster?
Lordship, nobody is appearing for the headmaster, my Lord, and the same government.
Under which department?
Will be the here. It will be a private respondent, Lordship. Respondent number 4.
Understood, but then also is under the control of something. huh?
My Lord, he is private individual, but the inspector's school is under. Inspector's school is under the education department, but headmaster generally privately appeared, my Lord.
Understood. That I understand, but what needs to be done is you instruct the inspector
Yes.
To inform the headmaster so that he gives the non-drawal certificate.
Yes, Lord. If I may, Lordship, as per the Treasury officer instruction, that headmistress has been informed also, but the response is not coming from the headmistress. That is one issue which the Treasury officer has highlighted, my Lord. Maybe Lordship has been requested by the Treasury officer as well as the inspector of schools, Lordship, on the instruction.
Second, but she is refused to accept.
What is happening as regards service upon him?
Yes.
Respondent number
4, Lordship.
4. Notice of the respondent numbers.
I have taken step on 22nd.
It was only sent on 3rd. You take service by way of Dusty.
Yes, madam. She is refused,
You have done it.
but I have not filed the affidavit.
He has refused.
Yes, ma'am. She is refused.
It's a headmaster or a headmistress?
Headmistress.
We do one thing. I will instruct the inspector of schools to serve a copy of this order upon the headmistress, and you also, through Dusty, you do it. Then otherwise, if then also nothing happens, we can call her in person. Then it will be better.
My Lord, Dusty,
Mr. Counsel, I'm trying to help you and you are not. You see what is happening, the Treasury officer has asked. Now tomorrow the inspector of schools, I've asked them, if nothing happens out there, how do I call her? So an order is to be given so that you give it. So that this court tomorrow takes up the stay that in spite of that, if he doesn't appear, then we will take steps against her. Ask her to be personally present. And if she doesn't, then we'll ask the SP to arrest her. Don't you think it is a better option? Heard, Mr.
K. Kolita.
K. Kolita, the learned counsel appearing on behalf of the petitioner, Mr.
You, Sharma.
U. Sharma appears for the Secondary Education Department. Mr. S. R. Borua appears for the Director of Pension. And Mr. A. Solia appears for the Finance Department. It has been brought to the attention of this court that the difficulty on the part of the Treasury officer to disburse the pension to the petitioner is on account of non-furnishing of the drawal or non-drawal certificate by the DDO. That is the headmistress of Duliajan Uচ্চ Vidyalaya Duliajan. It has also been brought to the attention of the court that the treasury officer had also taken steps against, have also issued letters to the headmistress of the said school. But then also the drawal or non-drawal certificate have not been issued by the concerned headmistress of the said school. In that regards, a bunch of the instructions have been placed on record, and the same is kept, instructions have been submitted before this court, which is kept on record and marked with the letter X. The learned counsel for the petitioner also had submitted that the petitioner had taken dusty service upon the respondent number 4, but she has refused to accept the same. Considering the above, this court deems it proper to direct the inspector of schools to serve a copy of the instant order. No. Schools, it will not. Considering the above, this court directs the inspector of schools. Where? Inspector of schools what? Which one? Dibrugarh. To serve a copy of the instant order to the headmistress, to the respondent number 4. So that the only obstacle, for non-release of the non-disbursement of the pension to the petitioner is on account of the non-furnishing of the drawal or non-drawal certificate by the headmistress of the school, that is the respondent number 4. This court therefore directs the respondent number 4 to forthwith, upon receipt of the instant order, to submit the drawal or non-drawal certificate in respect to the petitioner to the treasury officer Dibrugarh, Naharkotia. Good stuff. This court further directs the inspector of schools to furnish a copy of the instant order to the respondent number 4 for due compliance. The petitioner is also directed to take steps by way of dusty to serve a copy of the instant order upon the respondent number 4 and file an affidavit of service on or before the next date. Let the matter be listed again on 3rd of April 2023. So that Mr. A. Salia, the learned counsel appearing on behalf of the Finance Department, can apprise this court as regards the present status of the disbursement of the pension to the petitioner. The registry is further directed to furnish a copy of the instant order to Mr. U. Sharma for doing the needful in terms with the above.
Lordship, in the meantime, Lordship, if the petitioner can visit the treasury officer once, because in point 3 of the letter, my lord, there's some verification needed to be done regarding the specimen signature. Lordship, page 2.
The petitioner is further directed. Petitioner is also directed by the instant order to visit the treasury officer Naharpati for verification of the specimen signature and for identification of the petitioner as per the descriptive rule and furnish. He is to furnish the bank account.
Lordship, because it's not available, Lordship. If they can
Furnish such other details
yes, Lordship, they can
as so sought for by the treasury officer Naharkati.
yes, Lordship.
In the meantime.
46.
Yes.
I think on the last occasion, Lordship had directed the higher education department to apprise the court regarding whether the petitioner was put to notice at the time of revision of the fixation of the pay, that even in the event of any excess amount has been given, he will be that will be recovered. So I have sent letter, Lordship, and director has sent letter to the college also. I have not received the instruction. Not the instruction yet.
Mr. Counsel, you get time till 3rd of April. Get your instructions, else this court is going to dispose of. If there is further delay out there, this court is going to impose interest from the date the amount of rupees 2,90,000 has been recovered. Heard Mr. A.R. Tabildar, the Learned Counsel, Standing Counsel, appearing on behalf of the Higher Education Department, who further submits that he requires some time for obtaining the instructions in terms with the order dated 10/2/2023. It appears on the records that pursuant to the order dated 10/2/2023, Mr. A.R. Tabildar had, on the earlier occasion, on 22/2/2023, had sought for time. Almost a month have expired and till date, no instructions have been received. This court fixes the matter again on 3rd of April 2023. If in the meantime, the instruction sought for is not received, or further accommodation is sought for, this court puts the notice upon the respondent authorities that interest would be imposed upon the said respondent authorities if in the circumstance the instant writ petition is allowed. List the matter again on 3rd of April 2023.
47.
Yes, Mr. Sinha.
Respondents have to file affidavit. As per last order.
My lord, pursuant to the order passed by this honorable court, Lordship may kindly see page 80, only one paragraph, short paragraph.
Page
80, Para 16 of the order, which was passed in favor of the petitioner. In view of the reason cited above, the respondents are directed to pay and release the salary to the petitioners at par with the allopathic medical officers of NHM, Assam, with effect from the date of filing of the writ petition, that is 18/12/2018. Pursuant to that, at page 81, we have already issued this order. They are agreed by it. Lordship will see the chart. Current initial remuneration 30,500 per month, revised initial remuneration 40,000 per month from 18/12/2018 to 31/3/2019. Thereafter 50,000 per month from 1/4/2019. So we have issued this, but they are agreed by this. This is the my lord remuneration which was paid to the allopathic doctor from my lord 18/12
Under NHM.
under NHM. That
So
is the
this has
special
been
order.
duly complied with.
Why they are agreed, my lord, that's difficult to understand.
Yes, madam. Your lordship may kindly read that calculation, madam. Then next paragraph, the existing medical officer IU directors under NHM are hereby eligible to draw revised initial remuneration. Condition has been imposed for the corresponding period as above from 18 to 7 in case drawing lesser remuneration per month. So those who have already crossed 50,000 or 40,000, they will not get this amount. Whereas the disco directed to ACPA, because if we the salary was ACPA in the session of 2012-13. If we calculate the salary structure of those MO MBBS under NHM minor, so it will more minor. Now here, by in course of time, because on the basic remuneration there is also my lord annual increment is there. By
Mr. Gogoi,
My lord, we file a
I
affidavit,
think
my lord,
you
during the
file your
calculation.
Yes, madam.
Mr. B. Gogoi, the learned counsel appearing on behalf of the NHM,
madam.
submits that he requires 3 weeks' time for the purpose of filing the affidavit. Let the matter be listed on 10th of May 2023. In the meantime, the learned, the standing council, the respondent, the respondent are directed to file their affidavit by 2nd of May 2023.
Well,
the petitioner, if so advised, may file their affidavit by 8th of May 2023. File their reply by 8th of May 2023. List
Okay.
accordingly.
Last time there was an order to list the matter in the admission, not the stay matter. Here again today matter has been listed for stay matter in the
It can
there
stay.
is no stay here. madam.
stay, not stay, it's only
List the matter for admission
admission.
on 10th.
All right.
50,
Yes.
Yes, instruction was called for, my lord.
Yes, you got anything?
I need some time, my lord. We have no-
Why? Oh, less time. 7 days have only gone, na? But anyway. Oh, that one.
My lord. My lord, my interim may consider, my lord.
Oh,
Because,
yes.
my lord, I was not,
Interim means what do you want? You
My
want to
lord,
be reinstated.
my lord.
You want to be reinstated.
It
You
was
have been-
No, my lord, it is transfer order. It may be state, my lord. Or status for, my lord.
Yes, why haven't you got the instruction?
Lord.
Mr. P. N. Sharma was appearing.
My lord.
Why?
Lord, he has told me that he has forwarded a copy of the order, man.
So,
Also, we have yet to receive them. My lord, some time may be granted. My lord. 1
no,
week.
there was a direction for interim order shall so sought for in the petition shall be taken up for consideration on the next date. You are not serious.
Well, I have gone through the order.
Then why should this court not
One
stay
week
that
time may be
order?
granted, my lord. I
Huh?
will bring the 1 week time may be granted. I will bring the instruction.
No, Monday. Leave it on Monday,
On Tuesday, my lord, before.
not Tuesday. Because here is a case where a petitioner has been transferred on the basis of some punitive action being taken without giving him an opportunity of hearing.
On Tuesday, my lord, I will bring.
Wednesday.
My lord. My lord.
List the matter again on Wednesday. Or no, list the matter again on 22/3/2023.
My lord.
On which day? It is observed that if the learned counsel appearing on behalf of the respondents do not get the instructions in terms with the order dated 10/3/2023, this court shall consider the request for the interim prayer on the basis of the available materials on record.
My lord, may I say one thing? As I have informed my lord, my lord DO, my lord informed the present petitioner if he is not my lord joining within 2 days, my lord, he may be suspended.
Till the next date, no coercive action should be taken against the petition.
Obliged. Thank you.
Number 49.
No, I don't have matter. This is the matter.
Yes.
Orders, only 3 orders are left. No,
That
3 orders.
3 orders, your lordship can continue that 3 orders, then can be called thereafter. And can-
Forty-one.
Well, I have to take steps, Dusty, my lord. OP received offered but refused to accept. So I have to file APD. 14-3 office note. He refused to accept. Dispute between 2 wives for family pension.
Whom?
To the my lord, first wife, my lord. So to be both of us, we already, my lord.
You are a second wife.
I'm the second wife, my lord.
What is your case?
Case is that, my lord.
You want family pension?
Family pension, we were getting, my lord.
It has been stopped.
Stop, my lord, because
Rightly
it is-
so.
From the last 9 years, it is not regular the pension, my lord. Only provisional pension, my lord.
Then,
So both of us, we have the understanding along with the opposite party also, my lord.
so
But
what case you have?
but
after
she
the
is
full
refused to
bench?
accept the dusty service.
Forget about that dusty service.
Yes, my lord. So
You
I
never
have
know.
admitted
When
to
the
them,
motion matter also, it gets dismissed.
90,
Dusty service also, it gets dismissed. Yes.
90.
But what right you have?
But yeah, this is the Muslim moment.
Huh?
Muslim moment.
Understood. But you are the second wife.
So 50-50, there is an agreement.
What is this 50-50 business? The 50-50 business will be there. By the department shall do it, not for this court to decide all.
Can you pay your lordship the joint affidavit, my lord?
Forget about the joint affidavit. Why? This court is going to do it. Have you read the full bench judgment or not?
Yes.
Then, do you have a case? Honestly,
Honestly,
you have a case?
we have the understanding as Caesar.
No, honestly tell me, do you have a case in view of the full bench?
In view of the full bench, it is not, my lord.
And then
Because
matter
first
ends
wife
there.
will take, and thereafter it will be distributed, my lord. Anyway, my lord, I will take steps, my lord, dusty service, my lord. And that is they are in the office.
You have not taken.
Not taken, that's why. my lord.
Is there any stay?
No stay order. No. And regular pension also not released because of our dispute.
We'll have it after 5 weeks.
Yes, my lord.
You want it?
4 weeks, my lord. 4 weeks.
You need 4 weeks for dusty service.
No, my lord. Dusty, I will file affidavit within next week, my lord. Thereafter, you will also pay.
We want this should be dismissed on the day.
No.
Next day itself it will be
She is
dismissed.
not opposing me, my lord.
Who?
At other side also not, she will not oppose because of our dispute. They
Then if you are not opposing, then why haven't you approached? This is a matter of 2022. Does it look nice? These pension matters are standing out there from 2022.
9 years regular pension also not released to us.
Who are you?
I'm the second wife because
So I know that you are the
Yes,
second
yes,
wife.
yes,
Why are you asking all these things?
yes,
Regular pension of whose? The husband's.
husband, my lord.
He died.
He died, my lord. 9 years.
He didn't get any pension.
He got it, my lord. But subsequently, family pension has not been released.
Only family pension. So
Provisional
why we
pension
are
released.
concerned with the others?
Yes, yes.
This is the matter after 2 weeks.
42.
Then matter would come after 2 weeks, my lord.
I'm praying for a review of the order dated 4/1/23 passed in WPT number 2121 of 2015. The order
Where is Mr. B. Gogoi? Mr. B. Gogoi was there. Is that the case where this court, where's that order? Yes.
page 68, doctor. Starts at page 68.
No, which order? Review?
Page 68, Lordship. It's
Page
68.
68.
Yes, Lordship.
68. Yes.
The Lordship relevant portion is it is from paragraph 6, Lordship.
Hmm.
In paragraph 6, Lordship, it has been stated that, Lordship, the rules of
No. I remember this case.
yes, Lordship.
This Mr. Gogoi, you remember this case?
Yes,
This was a
yes.
case whereby Mr. Sahu had moved it
Yes.
on the ground that he had not been. I said that no, he is not entitled to.
Yes.
Then a document was shown by which he was taken into, it was taken that he should also be promoted on that
Already
ground.
promoted.
He had been promoted on the ground that, but in the meantime, the rules have been amended.
Yes.
Then under what circumstances you are seeking a review?
Lordship, this amendment, these rules are applicable only as guidelines in our establishment.
Huh?
These rules are applicable only as guidelines, Lordship, in our establishment. Because there is an office memorandum of 1999, Lordship, wherein it has been stated clearly.
99. In view of the office memorandum dated so and so, which applies to the department, you say that these rules are only guidelines.
Yes, Lord.
Then in that case, your appointment should go.
Lord.
You see, Mr. Sahu's client, who was there, the petitioner out there, if we say that matriculation is or the graduation is not required, then in that case he comes within the ambit. He is senior to you.
For that, Lordship, I have annexed. Sir,
I think it's a case of appeal.
it's a
It's a case of appeal.
because, Lordship, these documents were not there, so I brought it on record, Lordship, to this review, Lordship.
A case of appeal. Have you now been removed or not?
Yes, Lordship. I have
Very
been
well.
removed. Lordship will kindly peruse the office memorandum once, Lordship. Then it will be clear, Lordship. And the rules, Lordship will kindly have a look. The rules, Lordship, they will have to adopt it, Lordship. Otherwise, it cannot be made applicable directly, Lordship. In the rules itself, it's been provided.
Where is the office memorandum?
Lordship, herein it's at page 43, Lordship.
Page?
Page 43.
Yes.
Lordship.
Promotion to grade 4.
The third paragraph, Lordship.
Hmm.
As there is no service rules for the establishment of the subordinate offices under this commissionerate, the Assam Ministerial District Establishment Service Rules 1967 is generally followed by subordinate offices for guidelines wherever necessary. It's for guidelines only, Lord.
According to the provisions of clause B of so and so, the rules as amended by so and so, the vacancies of LD assistant of any year is to be filled up by way of selection on a merit, and a man have rendered 7 years of so and so. Find out the head of the officers are advised to take action on the following line for such promotion. Find out the names of all grade 4 employees of the establishment who have passed. Now, this was done at that point of time when the rules stipulated categorically that it has to be HSLC.
Yes, sir.
Now it is no longer SSLC.
Okay. But the department has been following that, Lordship, because I have annexed that annexed to Lordship at page 75, Lordship will find that. Lordship.
Page
75.
Yes.
It's a communication from the commissioner, Lordship. Therein, Lordship, similar persons.
With reference to, I have the honor to report you that in response to the letter caption, I perused the records of the establishment regarding the promotion of transcribed from the record. But there is no How is this relevant?
Because
Does the Assistant Commissioner of Taxes have the power to issue circulars?
it's the
Yes, Mr. Gogoi, what is your stand?
Well, regarding that, my lord, circular, it was applicable, but our stand now is that, my lord, since in 2015 it has been amended. So automatically, my lord, so far as the criteria for promotion to the next level post will go up, my lord. We cannot, my lord, the entire state, my lord, there will be one criteria following which that notification was issued. Subsequently, if it has been enhanced, my lord, we will have to follow that. In fact, there are instructions from the government to this effect, to the commissioner, that this will have to be followed. The amended part, that I can place, my lord.
You
That I will
produce
place,
it on
yes.
next occasion. When do you want it?
Well,
Kindly have a
next
look
week
at
is
the
that
rules also, Lord. Kindly have a look at the rules also, Lord. They will have to adopt it specifically, Lord. The route in the route it is being provided, Lord. But
Every time they have to amend, they will adopt it.
no, Lord. If the ministerial
Mr. B. Gogoi, the Learned Counsel, appearing on behalf of the respondent state, respondent finance department submits that he would like to take instructions in the matter. Leave the matter well.
Well, after 1 week, I can have it from here.
We'll have it on another date. With it.
Any day convenient.
We'll have it on 28th of March.
well, fair, Lord.
Yes, no stay.
Lordship, recovery, I have been told, Lordship, recovery is going to be made from his salary because of that demotion, Lordship.
We'll see. Has the recovery order come?
No, Lordship, but then no adverse action may be taken, Lordship, because he's a grade 4 employee.
Sorry, unless I issue notice, then the question be. I am not issuing notice.
I understand. Apply.
44,
What do you want?
May please, Your
Lordship, family pension, Lordship. My son died on job, Lordship, and
Then what do you
I'm the
want?
mother.
Your Lordship, in this matter, they have filed an IA, Your Lordship, and we have not been solved to copy, Your Lordship.
Miss so and so, Mr.
DJ Bora, Your Lordship.
You're paying for?
But respondent number 4.
Appears on behalf of the respondent number 4 and submits that an interlocutory application has been filed, a copy of which has not been served. The petitioner is directed to serve a copy of the petition application by within 3 days from today. List the matter again on 3rd of April.
Obliged.
45,
Yes, Mr. Doctor.
My lord, I'm the applicant and the respondent of the writ petition.
What order you are seeking for amendment?
My lord, for modification and setting aside the interim order, my lord.
Oh,
Whereby on the basis of this, my lord, you are reinstated.
huh?
May I have an adjournment for today? My senior is in late only for the day, Lord.
Still in legs in some court?
Lordship, yes. Lordship is in court number.
Suspension, impugn order of suspension shall remain stayed. Who has been suspended?
18, page 18, my lord, this is the interim order. My lord.
List the matter for, we'll have it on, in fact, this, let the matter be listed again on 24th of March 2023 in the stay vacating column. Will come on top.
My lord, on the same offense, one is out of the service and one is officiating.
Okay, we will see. Yes, Mr. Das.
49,
Hello, I was showing last P09 that it is the remand is a judicial function, their judgment. Thereafter, my lord.
You were referring to the 53.
That's
Yeah,
I'm
what is that?
connecting it. Earlier it was 344 is a parameter with 309.
Okay.
So I was showing with the judgment.
Show me para
1953. Last 3-4 lines kindly see that trying magistrate was obviously
proceeding at that stage under section 344, which is my
Where,
lordship
where?
parameter, criminal, which requires him, he chooses to adjourn.
No, which paragraph?
19 paragraph 3, my lord.
Okay.
Paragraph 3, last 3 lines.
Ah, the trying.
The trying magistrate was obviously proceeding at that stage under section 344. My 340 parameter with 309 of the old act of so and so, which economy chooses to adjourn the case. Now this is your lordship will leave that apart. Now kindly turn to next page, my lord. End of this para 3, end of the para 2 line. This warrants contents or the back the following endorsement remanded to judicial till 11 March 1953. Your lordship got it? So this is a order of remand. Now lordship goes further down, last 4 paragraphs. This court has often reiterated before that those who feel call upon to deprive other person of their personal liberty, my lord, meaning the learned magistrate, in the discharge of what they conceive to be their duty, must strictly and scrupulously observe the forms and rules of the law. So the rules of law under 309, my lord, and 436A has to be strictly followed. This is what I have to say. It's a full bench. This is gone. This is a constitutional bench judgment. My lord. Now I will take to your lordship.
Answer my question.
Yes, please.
To the effect
That
that
is
what is the scope of objection that a PP has?
PPA.
Scope of an objection in the proceedings under 436A. What is the scope of it?
I will just explain to your lordship what the scope. That's why I tried to convince your lordship about 309, which has a connection with the scope of the PP. Kindly see the CRPC. And in connection with that, what your lordship has put a query, I'll give an answer to it with a judgment of the Supreme Court. My lord, can we take this? Yes. 436A, my lord.
Yes.
436A. When a person, may I read my? When a person has during the period of investigation, inquiry or trial under this code of an offense under any law, not being an offense for which the punishment of death has been specified as one of the punishment under that law, undergone detention for period extending up to 1/2 of the maximum period of imprisonment specified for that offense under that law, he shall be released by the court on his personal bond with or without security. So past part is very clear, my lord. It becomes a mandatory. He shall. Now, if you see the second part, proviso, provided that the court may, after hearing the public prosecutor and for reasons to be recorded by it in writing, order the continued detention of such person for a period longer than 1/2 of the said period or release him on bail instead of personal bond with or without security. Now let us understand, my lord, the first part. First part is mandatory on the part. There is no question of any, my lord, security. It is on a personal bond because automatically. But when it comes to the proviso part, when it comes to provide, then again now it's not mandatory. It's a discretion because the word may. Now what normally it does, why I pointed out 309. When, my lord, 1/2 term is completed on 16/8/2022. Thereafter, his right accrues after 16/8/2022. When the first remand is produced before the court after completion of 1/2 term. So what the learned magistrate does, then 3092 has to be looked into. He is produced, the learned magistrate looks into the order, then he has to apply his mind. Now, when he is applying his mind, my lord, under 3092, now this 309 from here, end with 309, then he remands back. Now, in between 436A comes into play. Now, what he does, the record is before him, my lord. Now, once this particular period is over, first remand, then what he'll do, he will see the records. Once the records is looked into it by the learned magistrate, 1/2 term is completed. Then my humble submission, your lordship's query is that
he has to put a question to the learned public prosecutor and to the accused itself. This part, my lord, with great respect, has not been decided by the apex court on this issue, which your lordship is asking. I tried to find out some judgment, I could not find out. What happens in between 309, starting point, is produced before the court. Now it ends again. He is applying his mind. Maybe he may release or may again he may remand it. In between 436A, he looks into the file and says 1/2 term is completed. Then the second provisor will come. He'll put a question to the learned public prosecutor. Look here, he's completed 1/2 term. What do you want to say? Whether you have any objection to it, he may raise an objection. Now it is a discussion. Your lordship may accept the objection, may not accept the objection. So that's what I am saying, that this is the part where it is not that by a written, I may file it, I may not file it also. Application. Unlike 167, this is your lordship will keep in mind. 167.2, that's why I have shown my law. Difference on 167.2 and 436A, there is a difference. 167.2, my right, it extinguishes. 167.2, mandatory period, charge sheet has not been filed, my law. Charge sheet has not been filed. Then again, my law, the magistrate will ask the accused. You see here 167.2, you have come to your right accrues because now they have not filed a charge sheet. So now it's up to him because there has to be not a personal bond. Security has to be given. Now the accused may say that I don't have any securities. So there he remains. Thereafter, my lord, charge sheet has been filed. Then he cannot go back and say, now I have found. So please, 167.2 again will come up. No, his extinguishes is right. But 436A, my lord, it will continue. It may so happen, let us put for an example, a situation. My lord, proviso, I am saying that the magistrate, my lord, put a question to the learned PP that whether you have an objection, 1/2 term is completed. He says, I have an objection. What objection you have? Some most material witnesses are to be examined. So no, his particular, there is a chance that he may temper. Threatening is there. That may be reason. That may be reason for not allowing him. It doesn't mean that extinguishes is right. Once the most material witness is over, again he can come with an application under 436. This is what my humble submission before lordship. Once 436,
you are saying 436A is recurring.
Yes, it will remain till the completion of the trial. Full term. Full term it will remain. My lord, in terms of the second proviso, kindly see the second proviso. Provided that the court may, after hearing the public prosecutor and for reasons to be recorded by it in writing, order the continued detention of such person for a longer period than 1/2 of the same period, or release him on bail instead of personal bond. So longer period means he can full term. It can be a full term, but he has got that right. That right doesn't extinguish. That right continues under 436A on the proviso part.
So you mean to say
Now kindly see.
no, Mr. Das, you mean to say that the objection which the magistrate can, the PP can do is not only limited to the delay, but all in respect of all other aspects also? About tempering also?
No. Then your lordship has to look into the judgment of Satyendra Kumar until.
That is why if we go into what you are saying, that if he says that he may temper with the witnesses. Can it be the reason to withhold the right under 436A,
No, then he
under
cannot.
21?
He cannot withhold. He may, my lord. That's
What
why
is
I'm
the
saying-
scope of
No,
objection?
He may. That's a scope of objection. He may say a lot of things on merit of the case. They see that will temper so and so, but that will not be taken into account so far as 436A is concerned.
That is
Because
what I'm saying.
436
What is the scope of his objection?
So no, kindly see that only caveat paragraph 47 of Satyendra Kumar until. Kindly see 47, my lord. The Satyendra Kumar until. That's only he can have.
not beyond that.
What is the, let us
Yes.
read it again.
47, man. Under the provision, when a person has undergone detention for a period extending to 1/2 of the maximum period of imprisonment specified for that offense, he shall be released by the court on his personal bond with or without security. The word shall clearly denotes the mandatory compliance of this provision. We do feel that there is not even a need for a bail application in case of this nature, particularly when the reasons for delay are not attributable against the accused. We are also conscious of the fact that while taking a decision, the public prosecutor is to be heard, and the court, if it is of the view that there is a need of continued detention longer than 1/2 of the said period, has to do so. However, such an exercise of power is expected to be undertaken sparingly, being an exception to the general rule. Once again, we have to reiterate that bail is a rule and jail is an exception, coupled with the principle governing the presumption of innocence. We have no doubt in our mind that this provision is a substantive one, facilitating liberty being the core fundamental of Article 21. The only caveat, as furnished under the explanation, being the delay in proceeding caused on account of the accused to be excluded. This is the only caveat, my lord. There cannot be any other reason.
No, but if you see, however, such an exercise of power is expected to be undertaken before that.
Yes.
We are also conscious of the fact that while taking a decision, the public prosecutor is to be heard, and the court, if it is of the view that there is a need for continued detention longer than 1/2, has to do so. Meaning thereby, it is not only limited on the question of delay. He has, the public prosecutor can have the power or has the authority to make objection, raise objection in respect to any other aspects also, not only on the question of delay.
But only what I find by reading of this paragraph 47, the only caveat, your lordship has to look into the caveat, is only in respect of account of delay of the accused, not beyond that. Why, my lord, this particular 47? Only the caveat I find. I have given an example. What I said, an example to your lordship, that when 1.5 term is completed, in our case, let us see that 16/8/2020 that half term is completed. Thereafter, the first remand. So if it is a first remand after 16/8/2022, and it is a duty of the court, what I was saying, this part, man, I don't find anywhere. 167(2), I find one judgment where, my lord, it is the duty of the magistrate to tell either to the accused and tell the accused to look here, your 1/2, your 167(2), you have a right over it. But unlike this, my lordship has read certain until there is no need of filing a bail application also.
Meaning thereby the magistrate on his own accord,
yes,
can release him once he has completed 50.
But before releasing, there is a proviso. There is a proviso. There is a proviso that discretion has to be used by the magistrate. That proviso part. So only when it will come when there is an objection raised by the public prosecutor. And that objection, my lord, the magistrate may accept or may not accept. That's a different thing. May is there. Accept or may. No, I don't accept it. Because there cannot be a ground, that cannot be a ground that there are 40 witnesses to be examined. So that person may temper, so I'll put him in custody. Then the basis of 436A is frustrated. What is the intention of the register? That is frustrated. My lord, I have found one notification of our High Court. I'll produce that 17/2/2023 of our High Court that has been circulated. That has been, keep that notification. That second comma until has to be followed. Kindly see that notification of 7 of our High Court. See that notification. See that notification. I found, my lord, today that this was not being followed. That is not it. My lord, I have done certain few cases in remand, my lord, in our particular state, there is no reason. But when in Calcutta, I have seen all remand has got reasons. When it is produced, there is a reason. So if there is no reason, what you presume, my lord? If there is no reason, we presume that yes, it's not required. Kindly see, my lord. That is 10/2/2023. Register judicial from register kindly district and session judge. Order dated passed by the Honorable Supreme Court. Satyendra Kumar until. Your Lordship, this one. I think your Lordship is reading this.
Yes.
Well, kindly see, this is 10/2/2023. It is addressed from register judge to all the district and session judge. Kindly see reference order dated so passed by Honorable Supreme Court, Satyendra Kumar until. With reference to in terms of the order, the Honorable Supreme Court will directly request you for his information, respective district with regard to grant of bail. The information now, if you see like part A column, my lord will get first column, second, third, fourth, fifth column. Fifth column, whether direction passed in Bhim Singh versus so and so for release of under trial prisoner eligible for bail under section 436 of the CRPC are being complied with para 73 of so and so. So what my answer, my lord, what my learned friend has said yesterday, that this become a directory, my lord. I do.
No.
That's what I was given an answer.
Mr. Pukun also knows that is not.
Now your lordship was asking.
But the only thing is, this court is only thing because can you equate? Can you equate the powers under 436A to 439 and 438? You see, the parameters are different, which I have been saying from all along.
Right.
The reason for bringing 436A is that the one half you have already done. In fact, if I may give you an instance that in Punjab and Haryana, then they had a rule at that point of time when 436A did not come into the picture. This was brought only in 2015.
2005. 2006. June 2006.
Which one?
436A.
June 2005.
No, it is 2005. Applied in 2000.
Yes, 2006.
Applied.
Yeah, but there's a rule which is already there, which was not applied here. That one half you do, you are to be released. Means when in the matter goes in appeal out there. So that used to be the rule. Now, you see, the only thing is, can you equate the same scope of objection? Because here the reason of bringing 436A is because of the delay in for speedy disposal.
Correct, absolutely right.
Now, taking these suspension matters, the reason why the Supreme Court in Ajay Chaudhary has said that look here, this suspension which you have done has to end fast. You can't have it if you are not initiating a department. NSS has fixed that if you don't serve the memorandum of charge or within this 90 days,
They have
the suspension has to go.
167.
167 too.
Analogy of 167.
Yes. So that is the reason why the Supreme Court has done that. Now, in the instant case also,
Yes.
taking into account that a person has already suffered half of the pension, half of the period.
Yeah.
This is a special right which is being given. And this right is already there, but it has to be in very exceptional circumstances.
Yeah.
When this right has to be curtailed. It may be that in a case where a person can influence the witness, the court can exercise that power.
No, if my lord is putting a particular that if there is a tempering of it.
Hmm?
My lord, what are the type of cases that has been given? My lord will kindly see that has been given.
I'm arguing on your behalf. Huh?
My lord, type of case is punishment for not being an offense is the punishment of death. Death has been specified as one of the punishment under 436.
No, the moment it is death, it is out.
Yes.
No problem with that. Because that doesn't come within the ambit of 436. But if it is not death, then in that case, it is a case.
But now it took 5.5 years for this particular entire trial. Now it is a failure of the state. If it is failure of the state, they cannot come with an application before the court and that 4.5 years after he said no, 30 more witnesses are to be examined. Then for the court will say no, we'll not take into the ground of that ground. How can we take that ground? Now this is answered what your lordship was putting a query in Vijay Madalan in 417, para 417. Kindly 1 second see 417 my Vijay Madalan 417.
Yes.
Be that as it may, in our opinion, this provision is comparable with statutory bail provision, or say the default bail to be granted in terms of section 167 of 1973 code consequent to failure of the investigating agency to file the charge sheet within the statutory period and in the context of 2002 Act, that's a PMLA, complaint within the specified period after arrest of the person concerned. In the case of section 167 of 1973 code, an indivisible right is triggered in favor of the accused the moment the investigation agency commits default in filing the charge sheet complaint within the statutory period. The provision in the form of section 436A of 1973 code has now come into being is in recognition of the constitutional right of the accused regarding speedy trial under Article 21 of the Constitution. For it is a sanguine hope of every accused who is in custody in particular that he should be tried expeditiously so as to uphold the tenets of speedy justice. If the trial court cannot proceed even after the accused has undergone 1/2 of the maximum period of the imprisonment provided by law, there is no reason to deny him this lesser relief of considering his prayer for release on bail or bond as the case may be, with appropriate condition including to secure her presence during the trial. So absolutely, my lord, subsequently they cannot file an objection saying whatever that, no, I have got some more material witnesses. Please allow us. And don't allow him to go on bail. That with humble submission, it will be in conflict with Vijay Madanlal case in 417.
Now let us take an example. There 50 witnesses are there.
Yes.
It is known that yes, day-to-day trial which is going on. But there is a delay being caused by the accused lawyer, knowing it. Look here, I am not going to get the bail.
Then, my lord, then he will not be entitled. Then it is a fault of the accused. Then it is fault of the accused. No, he will not. This is what, my lord, Secretary Kumar until says. It has to be fault on the part of the accused. Then no, of course, there can be no objection.
So is it your submission? Can we take it as your submission to the effect that the court, while passing an order rejecting a 436A, has to come to a categorical finding that the delay has been caused by the accused?
Yes, absolutely. That's my, your lordship can record it. That's my submission. My lord, the answer, your lordship will get in 418 of Vijay Madan Lal, your lordship is reading that. 418.
No, 418 I remember by heart.
Yes.
Where the Solicitor General states it. So irrespective of
If the
any,
person is there,
even if a terrorist also happens out there, that is not the matter. So, in other words, 418 says that if it is not a case of death,
Hmm.
whatever crime it is, the question of the crime does not indicate or is not an indicative factor for a grant of bail under 436. It's not a crime. You can't look into that this is a crime of such a magnitude,
Right.
or it's such a scam of such a thing. You can't look into that aspect.
My lord, your lordship is so correct. I found one judgments, whatever Ravindran judgment. He was a scamster. Pramod Kumar Saxena. This is 2008-9 SSC. Kindly see, we have not given that. Such a high magnitude, this was going on. This way, that way, there were case for 10 years it was going on. He comes to the High Court, says, see, look here, put in one court. Then, so Supreme Court, my lord, is a matter of Supreme Court. When he said, I should get the benefit of 436A, my lord will kindly see. Paragraph 12 kindly be seen, my lord. Paragraph 12. It was also stated that by the Code of Criminal Procedure Amendment Act 2005, Section 436A came to be inserted, which provides under trial prisoner other than one accused of an offence for which death has been prescribed on the punishment has been under detention for period extending to 1/2 of the maximum period of imprisonment provided for the alleged offence. He should be released on his personal bond with or without securities. Now, your lordship, we look into 29, para 29.
Let's see, what is para 16, para 15?
Para 15.
Yeah.
Para 15. That the deponent has also given a list of some of cases pending in the state of UP. It is the above and the petitioner was sent to jail, are unable to come out.
16.
As held by this court, mere long period of incarceration in jail would not be per se illegal. If the petitioner committed offence, he has to remain behind bars. Such detention in jail, even as an under trial prisoner, would not be violated to Article 21 of the Constitution. If the petitioner has committed non-bail offence, connection with those offences, he is in jail, the custody can never be said to be unlawful, contrary to law, and is not entitled to be enlarged on bail. But that is, my lord, the submission which is made by the state.
Yeah.
Now,
para 20.
para 20. The petitioner has also invited attention to section 436A of the code, which provide maximum period for which an under trial prisoner may be detained. It was therefore submitted to learned counsel for the petition that during the pendency, final disposal of criminal case, the petitioner may be ordered to be enlarged on bail or executing a personal bond.
Now para 20.
20, my lord.
Para 24 now.
24. Having heard the learned counsel parties and having gone to the writ
No,
petition,
para 23 also.
23.
Yeah.
Regarding the application of section 436A of the code, it was stated firstly the said provision came to be inserted by amendment of Act of 2005, which came into force in June 2006. And as such, he has no application to be present case. But even if the said provision applies to the case of petitioner, in view of several cases at various places committed by the petitioner, he would not get the benefit of aforesaid provision. It was therefore submitted a petition deserved to be dismissed. Then, my lord,
para 24.
having heard the learned counsel parties and having gone to the writ petition along with the annexer, as also counter affidavit, we are of the view that on the facts and circumstances of the case, the petitioner deserves some relief from this court. True is that at the part of the allegation of the prosecution, various offences have been committed by the petitioner, and those cases are pending at different places. But the other equally important fact also cannot be overlooked, that he is in jail since more than 10 years. Prima facie submission of learned counsel for the petitioner is well founded. Only if the petitioner comes out of jail, he may be able to make arrangement for repayment of the amount and also defend cases registered against him.
Then,
my lord, it goes 29, my lord, she will go on there.
31.
29, kindly see, my lord. 29.
It is there.
29.
The
So,
repetition of
yes, this is then 30. 30, my lord. In the statement of object and reason, it was stated there has been instance where under trial prisoner were detained period beyond the maximum period of imprisonment provided for alleged offence. As remedial measure, section 436A has been inserted provided when an under trial prisoner other than the one one accused of an offence for which death has been prescribed in one of the punishment has been under detention period extending to 1/2 of the maximum period of imprisonment provided for an alleged offence, he should be released on his personal bond beyond without security. Now 31, the learned counsel for the respondent prime right in submitting that no retrospective effect has been given to the said provision. NSS 436A does not directly apply to the facts of. Why, my lord? Kindly see, the judgment was passed when? Oh, yes, retrospective effect. Court does not directly apply to the facts of the case. In our opinion, however, the hard reality equally important also cannot be lost sight of the fact that the petitioner is in jail since more than 10 years. It would therefore be appropriate if limited relief is granted to the petitioner. So far as the consolidation of cases and trial of all the cases in one court is concerned, this is my lord. Now, my lord, here relief was also given if 436A was also not applicable. Relief was granted. Even if 436A was not applicable. Now, kindly see 32. 1. If the petitioner will apply for bail, an appropriate court will release him on bail on his executing a bond to the satisfaction of such court. So, because they have kept in mind the statement object under section 436A.
Okay, let's hear the PP now. Anything else?
My lord, one judgment. My lord, Ravindran judgment is very important. One judgment. It will say this will never end. My lord, 15 minutes time has been given to me. Such a high magnitude case, my lord. 15 minutes, that also was put to challenge. The learned trial court said, no, you will get only 15 minutes to interact with the defense counsel.
Oh, this one?
Yes.
Before bail.
My lord, proposition of law, my lord. Paragraph 17.7, last 3 lines. 17, Lordship has gone to it, my lord. Ravindran. The Lordship has gone to it and it's okay. Only one paragraph I'll trouble your Lordship with. My lord, in Hussain case, I think my learned friend has yesterday has also shown before of Hussain case. That particular one, paragraph 28 is very important, my Hussain's case.
Which one?
Hussain's, my lord. Hussain versus Union of India. That is 2017 5 SCC page 702. Kindly see one paragraph 28, my lord. Para 28. Para 28 for 4 lines. Para 28.
Yes,
Judicial service as well as legal service are not like any other service. The missions for serving the society. Mission is not achieved with a litigant who is waiting in queue, does not get his turn for. The Chief Justice and Chief Minister have resolved all the cases must dispose of within 5 years, which by any standard is quite a long time for a case to be decided in the first court. So, my lord, our case is 5.5 years.
As of now?
Yes. And there was an instance.
You got the right on 16/8/2022.
Yes. My lord, this is not the first case where the court has given a direction day to day. At one point in time, 2017 also, my lord, there was a direction. Now, kindly see 29.1.3. Efforts for, my lord, as a supplement to section 436A, but consistent with the spirit thereof, an under trial has completed period of custody in excess of the sentence likely to be awarded. If the conviction is accorded, such under trial must be released on personal bond. My lord, now this is important. Such an assessment must be made by the trial court concerned from time to time. My lord, for a moment, he has completed full term. But that assessment has to be made by the trial court from time to time. Whether it is a full term or whether it is a half term, that assessment has to be made from time to time. Where your lordship was asking a query, that how the trial court will keep track or not.
Okay, let us hear Mr. Shah.
Wait, please, Your Lord.
Tell me what is the reason?
My lord, the plain reading of these sections, my lord, 436A, the plain reading of the 436A. Here, my lord, what we have find, my lord, the does in all cases, because my lord, this section itself is a my lord axiomatic, my lord, because here, my lord, does in all cases, the accused is not entitled to my lord the release on bail under the provision of 436A. On exceptional cases only, my lord, the court has power to deny bail of the accused if the court is the view that there is a need of the continued detention. That these are the plain reading of the my lord, what I have find in the state provisions. Here, in the my lord, until.
No, what is the reason for continued detention?
My lord, there,
As per
yes.
the court
The
below?
main moot question of this court is, my lord, how this court opined that his continued detention is necessary. The first proviso where it clearly says that upon the objections of the PP, the court, if opined that, the court in the opinion that his continued detention is necessary. From where then, my lord, the detention is
Does
necessary.
he have
from
not?
where?
Doesn't he have to record reasons for that?
Yes, that from where? From the materials on record which is available before the
Has he
court.
done that?
Yes.
Where?
My lord, the objection which was filed by the landed court below by the public prosecutor, where they have clearly said that why this detention is necessary.
But does he deal with those?
Well, that's
He
why we
says
have,
that because of the High Court have said that I am bound by High Court.
yes, that's why,
Then
my
what
lord,
else?
I am again trouble you lordship to read the same.
The order, as per the
On that
court
day, my lord,
below,
the entire order was not, my lord, read before your lordship. Come to
not
page 269, your lordship.
Hmm?
Page 269 of the petition. Half of the portion has been, my lord, the read before this honorable court.
Page 2?
Page 269.
69. Yes.
From the second para, your lordship.
Yes,
On
I
the
read
other
that.
hand, Learned Special Public Prosecutor Mr. P. Kakoti has submitted that the accused preferred a bail application before the Honorable Guwahati High Court and had taken a plea that he had completed half of the term of the imprisonment and was entitled to get relief as provided under the Section 436 ACRPC. The Honorable Guwahati High Court considered his plea and refused to grant relief as a free. As per the directions of the Honorable Guwahati High Court, this court started examining the witnesses on day-to-day basis. The prosecution is producing witnesses and has already examined 38 witnesses, so that the plea of the accused petitioners regarding alleged delay caused in disposing of the case due
How
to
many
lapses.
witnesses you have, Mr. Fukan?
My lord.
How many witnesses?
Now, my lord, there are.
No. How many witnesses you have?
Now.
Total.
Total, my lord, near about, my lord, 70, 75.
My lord, as of date, it is 82.
82.
82. And lordship's last occasion, your lordships call me the furnish the how many years left. I have received the, my lord, the records from the Lord Court, my lord.
How much?
Here, my lord, only. There are, my lord, total 11 number of witnesses, 10 number of witnesses remain, including the IO, and one is, my lord, the sanctioning authority. Total 6 is remain, my total, my lord, 10, 11 plus 6, total 17 witnesses are left. These are the vital witnesses, my.
Why have you left these 5 vital witnesses as the last witness?
My lord, the day-to-day here, my lord.
No, understood, but why have you left it as the last one? Tell me.
My lord, because my lord, day-to-day basis is going on. My lord,
You
only
knew
one day,
it.
my lord, only
You
one
knew
witness
it. Isn't it within your contemplation that the matter of 436A right is there?
My lord.
Why have you taken up, or have you taken it for granted that the courts will not grant any bail to him all times to come?
No, my lord, it's not taken as a granted, my lord.
Then what
Because-
is the reason why you have not, if these are the most relevant witnesses,
My lord.
you should have done it earlier.
Because here, my lord, not only this, my lord, the accused who has already been examined. There are also many important witnesses have been already been examined.
Very
The
well.
approver and well. And these are the persons, my lord, who are also, my lord, important, my lord, witnesses in this case. And because the Supreme Court also, my lord, clearly says that this kind of offense should be treated as a class apart, not like any general offense.
Where?
Supreme Court says, my lord, this is economic offense, my lord, because these are the economic offense. And it should be treated as a class apart, not like treated as a, my lord, general offense.
So a murder case, a person who
Yes.
commits a murder,
My lord, yes, Supreme Court says this economic offense is a more heinous than a murder because a murder has did, my lord, in a heat of the moment. But this type of offense, my lord, committed in a
no,
cool calculated mind.
can't a murder be planned?
My lord, in some cases. But
If it is
it's
at
not
the
my
heat
language.
of the moment, then obviously the
not-
firstly will come in.
My lord, correct. My, it's
300.
not my language. Supreme Court language, my lord. What I'm speaking, my.
Very well.
The Supreme Court says.
Then what do you say? That the Supreme Court has stated in paragraph number 418. It was a specific submission being made by the Solicitor General to the effect that if you hold this to be mandatory, 436A to be mandatory in such a regard, then it will help the terrorists.
That's correct, my. But
And Supreme Court have used the terrorist term not only in regards person who have been in exercise of these guns and all, but also other financial terrorists also.
my.
Then what do you say about that?
But it's correct, my lord. The Supreme Court what is saying.
Then
But here, the proviso, my lord, itself says, my lord, here is, my lord, the first proviso itself clearly says it's not a matter of right. Bail is not a matter of right in all cases. That's why this first proviso was there. Otherwise, my lord, in all cases, everyone got bail, my lord. When the due to, my lord, in AR Antule, it clearly says sometimes why delay has been, my lord, occurred in court cases. AR Antule in case, my lord, para 86 or 85, it clearly says. Well, in some reasons, my lord, sometimes the delay was
Mr.
there. my lord.
Bhukan, are you going to compare the situation when the judgment on Antule was delivered and today?
No, no. I'm just.
Things have moved. Earlier, you have to bring them, getting a witness out there becomes a problem out there. Nowadays, you have to act fast.
My lord, correct.
Then, now the court below did not take into aspect at all the question of delay. It only went that the High Court has said that. Why should I?
It's correct, my lord. But here the learned court below, my lord. Here also they say that the Honorable High Court was pleased to consider
Again, the problem arises because of the Honorable High Court.
my lord. Yeah, that's why, my lord. If one, my lord, they
Now
have
tell
filed
me, Mr.
one question,
Bhukan.
one remains.
Yes, Honorable High Court have said many things, but the Honorable High Court, did it take into account what is the law of 436A properly without taking into account the judgments of the Tinder or the other one, the PMLA?
My lord.
Then,
That's
now
why,
the
my lord,
law
what-
when it is declared by the Supreme Court, it dates back to its initiation, unless it is being given a prospective effect. So the understanding of the Supreme Court of 436A has to be understood as it stood as it came into force in 2006.
my-
And the High Court, the Honorable High Court, I will put it, did not take into account that aspect of the matter.
correct,
They have
Your Honor.
only made the reference, with due respect to the judge, they have only made the reference to those judgments which have been placed without any discussion. Only on the ground that this person would be influential. Can that be the ground on there? In all cases,
agree.
the person would be influential.
I agree by your lordship's opinion. My lord. Here, my lord, what I'm saying, my lord. Here, this is an applications under section 482. They are coming before this honorable for passing of this, my lord, the order dated which is passed by the learned court below, as well as they ask for the bail also. One questions remain, whether the 482 can encroach the jurisdictions of, my lord, the bail. That questions remains, my lord. They have filed a 482 bail applications, my lord. In the prayer, they said ask for bail and the challenge. This court may set aside the said order, my lord, if there is no reasoning order has been passed by the learned trial court. Set aside the said order, revert back the matter to take a fresh decision on that.
Then they will again take it.
My lord, if there is no any reasoning order has been passed by the learned trial, set aside the said order and revert back the matter to the learned court below to take a fresh decision on that and record the ground of the rejection why they have then my lord, entire matters will be clear, my lord. One thing this court can do, set aside the order. But how can, my lord, this 482 can encroach the jurisdictions of, my lord, debate?
Now, what do you say when the power which have been conferred upon the court having not been exercised? Wouldn't this court have the inherent power to exercise?
Yes, that is there, my lord. But Panful Nessa case, my lord, I have already submitted one document. Panful Nessa case, Niharika, and RP Kapoor. There are 3 cases where I placed before losses, where the Panful Nessa case clearly says, my lord, no. The 482 cannot be extended the jurisdictions of, my lord, the 439 and 430.
No, this is not a case of 439.
Yes, 436. It's also a case of bail, my lord.
No,
In his petitions, my
436 is a different power. That is what I have been all along saying. A power, just for example, if a case under 16, a default bail,
my lord.
which a person should have got it, he was
Correct.
not given. What does he have to do? Can't he come under 482 out?
My lord,
Because of the fact that there is a statutory power, exercise of power which should have been done by him and having not been done.
But in 167 too, my lord, we have found many cases, but they have filed a 439 here also, my lord, they have considered it 167 too.
So it's something like what is there in the.
But here in our case, my lord, why his detention is necessary, that I have already been, yesterday also I have been. My
What
lord,
is
filed
why
objection.
his detention is necessary?
My lord, because his conduct and earlier also he treated me. That's why my objections, my lord, I have categorically stated why his detention is necessary. Kindly peruse my objections, my lord.
No, he has threatened.
My lord.
What is your proof for that?
Yes, one GD entry is recorded in Dibrugarh, my lord, PS case. He threatened the, my lord, one of the witnesses.
A GD entry?
Yes.
Then why the
And my lord, the
as of
164
now,
statement-
why you have not convicted?
One of the co-accused, my
as
lord,
of now, why the court below have not yet convicted the petitioner hearing?
and moreover, my lord,
If it is so, if on a GD entry, one can come up and say that he has already threatened.
not only GD entry, my
Has
lord.
it been proved?
Not only GD entry, my lord, there is a deposition is also there and 164 statement also there.
So,
Against of the co-accused, my lord.
Has it been subjected to cross-examination?
No, my lord, before submissions, my lord, of the, my lord, evidence, one of the approver, my lord, in his 164 stated that, my lord, how she was treated. That was there.
But Mr. Pukon, could you say it to be an evidence?
My lord, at this stage, but 164.
Evidence would be something when it is tested to cross-examination.
Yes, correct, my lord. That
Then-
cross-examination already been going on, my lord.
So, has this person been cross-examined?
Yes, that Pelita Ninja has already been cross-examined. Probably. Because I have not seen her name in this petition.
That is an aspect which has to be taken into account. But there's threatening and all. Yes, this court can obviously put the conditions to that effect, not threaten the violation. Therefore, now tell me, what would be he has already done this for completed 1/2.
My lord.
A person who is being released on bail under 436A. And the Supreme Court in both the judgment puts that he can be put under certain conditions.
My lord.
What happens once he violates the conditions? He can be again arrested on violation. Then would he have still the right under 436A?
Is there, yes.
If you have violated the terms and conditions, would it be a case under 439?
Yes. I think
Not
it is
436A?
439.
Because if you see 417 of the judgment in PMLA, the Supreme Court makes it clear, yes, you can impose various conditions upon him. Now, what happens if he violates? Then his power still continues when his right.
Normally, if it is violated, then the public prosecutor has to come with an application for
cancellation.
Cancellation. Then a right will be given to the also to reply it whether. Then normally the cancellation is under 439(2) cancellation.
This is only 439(2) is only in respect to 439.
Yes,
A bail under 439.
yes, correct.
Not
But
in the
this is
case
not
of.
a case under 439.
Ah,
Your lordship is deciding case under 436A.
yes. Now, therefore, once as per 417, you put those conditions.
Yes,
In 417 of paragraph,
Yes,
you
yes.
put various conditions.
yes.
Now, what happens once he violates? Does he keep on getting the right under 436A?
Yes. That's why it says in exceptional cases only why not the bail was denied, not in all cases. That's why I'm saying in exceptional cases only why not bail is denied, not in all
Bail
cases.
is granted.
Yes, bail is denied, denied.
And this, but Mr. Phukan, one thing, I'm not at all pleased with the order passed by the court below.
Yes, correct, my lord. I have also seen my lord the order. It's my lord, the only they say that the High Court has rejected the order, so it's true. My lord. That's why I'm saying, my lord, set aside the state order, revert back the matter to the landed court below, and they have to decide afresh.
Mr. Phukan, as I don't sit in the criminal bench, so you don't know much.
No,
But I don't pass orders to the fact that for consideration. No,
my lord.
I only pass an order for consideration when I know that the person will get it. The court feels under 436A, he is entitled to this
Yes,
court
yes,
will
sir.
grant. But the only thing is, I think if I grant him the bail, I'll give you 7 days for effecting that order because of the fact then you, in the meantime, go to the Supreme Court.
Lord,
I think that is the best. If I grant him the bail, I'll give you 7.
Lord, sir.
Not to give effect to that offer order for 7 days, so that you can very well go to the Supreme Court and get a stay to that order if you can.
Otherwise also, there's 7 days, my lord, why your lordship? I'm telling. Otherwise, he has got every right to go to even
No,
bail.
no. The
There can be
moment
stay.
my order is passed,
Yes,
you have to be released.
yes, but even then the Supreme Court may say surrender. There's always option is there.
The
Why
Supreme
your
Court
lordship
may
will take
say
respect?
surrender. What happens to us? The Supreme Court can stay the order.
Yes, then automatically, my lord, I have to surrender. I have to surrender. If that order is there, I have to surrender. Yes. I have to surrender. So there is no, with great respect, no question of giving a handling to them. Their 7 days time is given. Again, your lordship, with great respect, cutting the right. Again, the effect of 436A. But if it is state for my Supreme Court, I have to surrender. I have to surrender again.
Hearing complete. Judgment reserved.
Simply. Much obligation.
We get the judgment on Monday.
My lord. Only what your lordship just closing it, that I have raised objection in respect of the liberty because that will be kept open, my lord.
Which one?
Liberty because the 15 minutes time is given to me.
For what?
For preparation of defense. Yes, in this regard, my lord. For preparation of defense by the learned trial court. Inside the courtroom, day-to-day proceeding, my lord. Only 15 minutes time was given to us.
For what?
For preparations of defense.
No, is that the matter before this court also?
Yes. I have challenged it. In this regard, my lord, I have objections, my lord. Whether the 15 minutes, how 15 minutes has been granted or not, what they have filed, that is not on record. Left part, your lordship, I have not published. That leave should be granted, we will do it in appropriate courts.
I think better off.
Yes, that's why I'm saying.
Kindly keep this, my lord, regarding this pair is there in his petition.
No.
Regarding 15 minutes.
I would not say anything.
My lord.
I'll make it very clear. I would not say anything, thereby giving him the leave to approve because
Yes,
I
yes,
don't want
correct.
to
Your lordship will
join
not
both.
put segregate
Hmm.
together.
15 minutes and all disrespect will be taken. In fact, that 15 minutes helps you.
Later.
So, Mr. Das, you have been put to state your
Much obliged.